Morning, afternoon, or evening. This is Stephanie Joy with Joy Disability. You're about to see a replay of the live Q&A of a recent session. They are generally 1 to 2 hours long every Wednesday at 1 p.m. Eastern Standard Time on this YouTube channel. So I hope you get a little tidbit of information out of it. Otherwise, maybe I'll see you at 9 a.m. for short little workday shares that we put out there on a daily basis. Take care. Hey all, can you hear me? I'm going to try to find the chat. Hi, Jeffrey. Hi, Sam the Man. Hi, Fuang Trong. Thanks for being here, guys. I'm just starting out. If you guys are here first, if you have any questions, go for it. Yeah, go for it. I am working on a few things here. Brooklyn's in the house. Hi, Salvatore. How are you? Yeah, good to see you guys. I was literally just working on updating a brief for a case that an under 50 person, I've had her for years now. And I just want to make sure you guys can hear me, right? I think you can. Hey, SGM, good to see you. And we were denied a hearing, not really surprise, because of the age factor and that whole vocational business, but we appealed it to appeals council and we got it overturned. And now we're going to our second hearing with the same judge. Unfortunately, for all times relevant, the person is under 50 because her deal ended over a year ago. It ended after the other hearing, but I think end of 2023. So that kind of stings. So the only relevant evidence is going to be up until that DLI of 12/31/23. I think our hearing was in early 2023 and maybe the denial decision. But so I'm just getting all the updated medical records into the brief. I'm kind of updating the old brief and adding everything. And I will be honing in specifically on what the appeals council said the ALJ did wrong in the first. Hi, Smalley. Hi, Karen. Hi, Crystal. In South Oregon. Yeah, so it'll be interesting. I have to have it in. I usually like to have these things in a month in advance, but it's just been so busy. So I will have it in by the deadline, which is Monday, but I'll have it in before then. But all right, I see a question from Karen. Let me pop it up. Trying to get good at clicking all the right buttons at the right time, guys, so you can see the questions too. So Karen, you just got approved for SSDI. Where on the award letter does it have a diary date for a review? It often doesn't. I don't even know if the field offices, the office that creates the letter, which I think is the field office. Sometimes it's like a Baltimore office, though. I don't know if they include it or if they do it sometimes or not other times. I know sometimes an ALJ will include a recommendation as to if there should be like an early diary. And I'll see that sometimes where they think it should be in, usually it's like 3 years. But so you might have to call them to find out. I know I would want to know, did they, particularly if you didn't go to a hearing, was it an MIE or an MINE? Is my improvement expected or, not expected? So you kind of know, it might just give you a little bit of ease, and just knowing what you have to prepare for, I think in itself is a bit relieving. So you guys are quiet. Deanna, did we see each other last week, Deanna? Or was that another Deanna? Let's see what Deanna has to say. Hello, I have a question about an appeal. I was recently denied for SSDI. I have a question. And 5 months after the original application was submitted. Okay. And I was diagnosed with a rare, incurable autoimmune disease. Okay, but I don't see your... Okay, here's your second question. Gotcha, Deanna. Here we go. How does this diagnosis get included in the appeal? You include it. Did you appeal yet? Let me just go back and see if you said you did. Recently denied. Okay, so Deanna and anybody else, if you have an additional impairment that came up after, or if you didn't include it on your original application because you didn't think it was important, or maybe you were under the misguided theory that you're putting in your one big one that took you out of your last job, irrespective of other ones. Either way, you put it in your appeal, because there is a question on the appeal form, whether you're doing it online or on paper, and you probably want to do it online, is that it says, are there any new conditions? There's one question about that. There's other similar questions like, has any condition you had gotten worse or better? And then there's another one, I think, about, have your activities changed one way or the other? And of course, for that one, I always say, yes. So you want to put it in your appeal. If you already appealed and you didn't put it in and something happened like a month later, you want to hop on the horn with that adjudicator if you don't have a representative to do it for you. And you want to tell them and give them the doctor that diagnosed it and tell them all the lowdown of anything that's going on in terms of treatment, medications, therapies. I kind of am in a I'm a paper trail person. So even if I call, I'm also going to put it in writing and I would be uploading it. You probably might not be able to upload it, but you can probably fax it in. They should have sent you a barcode if you can't upload it. I'm not sure. They're changing things all the times with the technology. And hopefully soon you guys will have that ability as well, like we do. Okie dokie. Did I miss somebody up here? No. Okay. All right, Smalley, here we go. I'm on SSD. The date of last insured is 2015. Wow. Yeah, that's a long time ago. If I decide to live in an SUV for a while, what will be my fair share of rent be? Thanks. If that's considered homeless, I would think there would be, you're not actually getting free home. I mean, if you live under a bridge, are you getting a free home from, I haven't researched it specifically if you're living in a car. I know when people live in like camper, it might be problematic. So you're obviously talking about SSI. So if anyone's wondering what we're talking about, it's SSI and whether what the rent to be paid needs to be. Again, I don't know that living in an SUV constitutes living in a place, being gifted shelter. I mean, honestly, if I told somebody they could live in my SUV, I don't think I'd be a very nice person. But yeah, so I don't know that it would, if you're going to be held to any standard for that. It's like being homeless. But again, going back to that newer rule about you don't have to pay fair market value anymore when you are, say, living with your parents or friend and they're not charging you. What would be, say, if there's 3 people there, 1/3 of the covering costs? Now you don't have to. You just have to be at least paying the presumed value, which is that 1/3 of the SSI figure, which is still under 400. So if you're paying 400 or you're not, but footing it for you as a loan until you can then pay them back once you get your feet back on the ground, be it through a disability benefit or winning the lottery or whatever. It is my understanding that 400 will suffice. You're not expected to now pay, if it's a $6,000 home, there's 3 people. Who's going to agree when they're broke to be paying $2,000? It doesn't make any sense. So they kind of get it that people with nicer places do want to, share their place to someone they care about if they need, when they're in need. Hope that helped there, Smully. Okay. EMM, good afternoon to you too. Williams, nice to see you. Oh, you're quiet to soak in the knowledge. That's really sweet. I hope I can give you some today. Deanna, you said that you spoke to the attorney's office who's handling your appeal and she said she wouldn't add it. I don't understand. Honestly, maybe she has a reason. Maybe it's not been truly diagnosed yet. Maybe it's in the workup stages, but you still want to have God, do I need a tissue again? In my opinion, she might have some details that suggest otherwise in this particular instance, but I don't know what that would be. It's weird to me. And Deb Lindley's right. You probably want to make sure you have a rheumatologist specialist, not just your primary care. I would like to think of a primary care. I don't see them do this all the time. Some of them do. Sorry, guys. I'm whipping my nose with paper towel. It's pretty nasty, right? I really didn't have a runny nose all day. I don't know what it is. But yeah, I always say go with a specialist when you have a special disorder. The PCP is just for the general stuff, not the things that have specialists that handle them, like autoimmune, could be rheumatology. I don't even know if there would be infectious disease or not. But, if you have musculoskeletal problems, orthopedist, sometimes neurologist. Okay. Huang, let's see. Just had my physical evaluation 10 days ago to determine if I am a sedentary or light work category. I am 56 age male with HVAC trade skills. I love those skills. Looks like DDD and MDD. So I'm thinking degenerative disc disease and depressive disorder, major depressive disorder. 100% TDIU and PNT. Grid rule apply. Yes. The grid rule applies to your age, but age is only one factor in the grids. I think it's already come out, a little update on the grids. If it didn't come out, it's coming out any day now, Fong, and it's I kind of try to break down and show you the actual grids yourself so you can see for 50 to 54 and 55 to 60. So you're in the age range. Even if you could do light work, Fong, at 50, cannot do the HVAC job you did if that's in the last 5 years. It's got to be in the last 5 years. And if that skill is not transferable to a job you could do exertionally, which, they'd have to find that you can't transfer those skills to a job. So let's say they find you could do light and you have those HVAC's trade skills can transfer to a light job. Now, if you can't do your HVAC, why is that? Is that because it's medium exertional level? That's what you're hoping for. If it's a light job, I don't think it is. What do I know? How much do you have to lift? If you had a medium job at HVAC and you were all you have to prove is that you're stuck at light or sedentary and that those HVAC skills do not transfer to a job in substantial numbers that is sedentary or light. So the grid applies to you. You just have to make sure your medical records put you at the right RFC, and that the medical records show you can't do that HVAC job, and that those HVAC skills, and again, assuming they are in the last 5 years, cannot transfer to a lower exertional job. Okay? I think you probably have a good shot. I think HVAC is pretty hectic. Just my opinion. Don't we love our HVAC? I do. I like my climate control. So I'm sorry. Okay. Crystal K. Are patient portal medical visit notes adequate enough to submit as medical records? I have quite a few doctors that have yet to submit my medical records. You know what? This is such a question that's out there. And I do get the portal records myself too for my clients to go in their cases. I do, although we still do the official ordering. And that's frustrating because, yes, it's frustrating when doctors, and provider offices violate HIPAA access rules. And it is a HIPAA access rule violation. And I think people should start reporting it to the OCR, Office of Civil Rights. It's super easy. It takes about 3 minutes. You can do it online. But getting the portal records is the next best thing. And okay, so like in 2019, the federal administration, the government passed a law that requires the providers, when you have an office visit, to upload those progress notes. Prior to that, guys, the portal records were squat. They didn't help a case. The only thing they did was let me know that you had an appointment. So I could, if my client forgot to tell me about an appointment, I could double check. So it was like a little double check, but I didn't have the records. And we still had to rely on these offices doing what they're supposed to do. And often they do, but you're going to have your percentage that just don't. They either have a really crappy office manager, because it's not the doctor doing it, by and large. Sometimes in the mental health world, it is, because they literally have no, I don't know if they're cheap or not, but they often don't have a lot of help in the office. So get your portal records, and you can always ask the adjudicator. Yeah, you don't say what level you're at. You can always ask the adjudicator, hey, have you gotten Dr. Jones records from Lehigh Valley Network? And if he says no, then you can get him your portal records for that fellow. Or if he says, yeah, but only up to, April of 2024, you can go in your portal. If you have hopefully it's like a MyChart Epic. That seems to be the best. I mean, sometimes I have to deal with portals from rinky-dink portal companies that are dealing with maybe some doctor's office that have not chosen to go with what I consider to be the gold standard. And then you have to go through, and sometimes they don't put up the progress notes. And I'm not even sure how they can get away with that under the new rules, because now if you have a portal, you kind of have to put them up. It took a few months. It was actually delayed a little bit, probably due to COVID or whatever, even though, yeah, probably due to COVID. I guess that's acceptable since it was in 2020, but now they're all pretty good. In my area, we have some major health networks, and they all thankfully use Epic MyChart. I do think it might be that health networks or doctors' offices can pick and choose how they use Epic and MyChart, because I haven't seen slight variations across the country when I have clients everywhere. So one in California might be a little different than what the particular ones in my direct area do, which is very robust. But I would always do the portals, guys, but still, and Crystal, your adjudicator is supposed to be ordering every provider that you put in your application or appeal, or in the middle of a pending application or appeal, you go to a new doctor, you shoot them up that information. They're supposed to order that. So don't forget to do that. But I would also, I like to cover my bases in all areas. So I get portal, we send out the requests when we see, we like SSA to do their part, but that's what the adjudicator is getting paid for, but we kind of keep an eye to see if those things are coming in a reasonable time frame. And usually the adjudicator will send out a letter saying, hey, we haven't gotten it from this guy. Can you help? And that's nice too. But now that we can see in the files, it's not as necessary, because we can see what they requested or what they didn't request. And I will be like, how come I don't see a copy of a request from you to Dr. Jones? Sometimes you got to do a little babysitting. Okay. Thought I missed somebody, but I don't think so. Thank you, Smalley. Smalley says, hit like, share, and subscribe. Thank you. That's very nice. I'm just scrolling down, guys, look for a question, because there's some really nice comments. Yeah, Crystal, I know it's really frustrating. I used to bang my head. I still bang my head against the wall sometimes with providers. I don't know what's up with your attorney, but maybe you should ask. the attorney might have a good reason. There could be some, I don't know. Brad K. I think we met before, right, Brad? Online. Thanks for all the guidance you provide. Oh, you're so welcome. I filed for my early Social Security for DAC. Okay, you filed for your early retirement so your child, disabled adult child, could get DAC. He's 22. And my wife filed for child in care. All finalized in 60 days first about. Oh, okay. This is just a good news post. Not a question. That's awesome. I'm glad to hear that. I don't know if this is material or not to the life you guys are living, but be careful to stay on top of the rules with DAC, particularly if your son is going to be working part-time outside of the house. You really want to pay close attention to the earnings and stay within that SGA. Really, really important. And of course, there's the old marriage thing too. Those are really the two things. Let's be rocking. You know, it's so funny. I think you guys, for those that came right from the start, did you hear music with that "Be Right Back" sign? I almost picked rock, but it was a little heavy for me. I'm a little softer than that with my music, so I didn't pick that one. But I saw that some of the things that you can pick, you have to be upgraded, and I'm not doing that yet because we'll see how this goes, right? But they did let you do that little thing hanging out and let you do a little music. So I was like, okay, I'm going to try that. It was kind of fun. It seemed to have worked. I'll see if when I scroll down, I'll probably see if you guys are saying that. For those of you that were here early on, did it have that thing up front and was the music on? I mean, I literally climbed in like on time, so it wasn't on long, maybe a minute, maybe two. I tried to put it on a little bit before the 1 o'clock hour. Chris, okay, I have clients, it's too late for you for sure, but yeah, California, I have PT time, Mountain time, Central time, and Eastern time. It really doesn't matter. We have a portal and people can go in and upload, download, leave messages anytime they want. And then what I usually do with my, I had a consult this week in California, and I don't want anyone getting up early for a consult. So I always try to make them be at least like, unless the person says, I love getting up at 7, which would be 10 o'clock my time. I'm like, all right, so I'll try to carve out like the 1 to 2 o'clock hour on my side and make that be my lunch hour or whatever, my consult hour. And then that way they're not getting in before 10 or 11 if they're going to consult. So they can be awake, right? Because some people, particularly if you're disabled, a lot of people aren't necessarily up with the birds like I might be. So never fear if it ever happens again. And hopefully this is going to work out just fine for you. Remember, your attorney, Crystal, has every incentive to win for you. Your attorney's not getting paid 1 red cent unless he or she prevails for you. So there is that. And it's an important that. Okay. And Williams. Phone interview last Friday. They called back this morning to finish up with my wife and I. Said I didn't qualify for SSD. Well, I don't know who was it for your wife or for you? SSD at that phone interview, that sounds like the field office. And it sounds like they were saying, when did you stop working and become disabled? Maybe you have a DLI that's really old. Did you already tell me above? Was that you? And then you wouldn't have SSD because you didn't buy it and you didn't have the coverage. And then you may or may not be eligible for SSI depending on your finances between you and your wife. Ripped Tinia. Am I saying that right? Rip DT Tinia. Hello to you too. You're welcome, Crystal. Sadaka, nice to see you again. Last year, my husband tried to apply for SSDI. He called for an appointment and was told he didn't have enough work in the last 5 years. I recently found out that he could have filed under DI. Want me to plug that in? DI 25. What can I do that? Maybe I can. Give me a second. I'm going to try to do something over here. Oops. So afraid of canceling something out. Oh, that's just the medical vocational profiles. You don't file under them, by the way. You file. And the SSA applies all the rules that apply to any age. So I don't know, maybe you should consult with an attorney or something. Now, if he didn't have enough work in the last 5 years, that suggests to me that he's not insured for Social Security disability. And you can't get it if you're not insured for it. However, if he hasn't worked in the last 5 years because 6 years ago he became disabled when he was insured, you can apply, but you have to say that's when you have to allege that's when your disability started, and that you didn't work SGA for any length of time after. So you really probably should just at least run it through with somebody and find out, because, I mean, he's going to be fighting an uphill battle if he has a remote DLI, date last insured in the past, but at least he still has that one bite of the apple. And, who knows, maybe he has great records. Maybe he treated a lot when he was out of work. If he was out of work for reasons other than medical, like he was just staying home with the kids, that's not going to work. Okay. Sometimes people stay home with the kids, lose their insured status. They're not disabled, but they're staying home with the kids, right? It's a beautiful thing. And then before they get back out in the workforce, which is hard after you've been in, even if you're only gone for 5 years until the kids get into kindergarten, it's hard. It's hard to go back, right? I think everyone should do it though, at least part-time. Start getting their feet wet because you have to build up those credits back again. Okay. Well, Sadaka, you're going on further. You say, last year my husband, no, it didn't come up. Hold on. Is there anything that can be done when they wouldn't take his application? Again, it might be because you guys didn't understand the questions about timeframes. So at least run it by somebody. If you want me to do a quick review with you, I'm happy to do that. It doesn't mean we can take your case necessarily. I don't know, but I'll at least tell you what's going on in terms of if you pursue it, this is what your parameters are. You can't say I became disabled last week. And the field office staff, God bless them, I know they're trying. They get it wrong a lot of the time. A lot of them are not well trained. They will give a date like right now, but you've been out for 5 years because you became disabled 5 years ago, and they're not going back to that. It's a mistake, and people get turned away erroneously. But if they had used the right dates when you were insured, when he was insured, then it would be different. Muley, I like your picture. Looks like a nice stag in there, huh? A book. What to do with an attorney who seems to be doing nothing with the case and doesn't want any records except the last 2 years to go to SF. Well, different attorneys handle these things differently. I don't know if that attorney is subject to rules that his firm puts on him and doesn't really have the power to do whatever he wants for the best of his case. If your records beyond 2 years ago, though, are not really relevant to today, and when I say that, it's like I do get older records, but they're never going to be the thing that wins the case. But sometimes I just think it's a nice little gravy, a little icing on the cake for a little historical perspective for my adjudicators. But it is true that those are not the ones that are going to win your case. So if he's going on that basis, it's true. And I guess attorneys can differ as to how in-depth they're going to be. Sometimes really old records, you can't get it all anyway because they're over 7 years old and we don't keep them, which makes no sense to me. Would they be keeping them if you sued them for malpractice and were able to toll the statute of limitations and get it back to them? I think suddenly they'd come up with the records, but that's just me. I think, okay, when you say he seems to be doing nothing with the case, the attorney, that's probably not true. Remember, he's got, and I say this all the time, I know I'm a broken record, he's got every incentive to prevail for you because he's not getting paid. And if he's an associate that's subject to the limitations imposed on him by his bosses. I always said we were as effective as our least effective boss when I worked at a law firm. So imagine the frustration I had, me being the type A that I am. I think I used to also say you're only as ethical as you're only as ethical as your least ethical boss. It was like the weakest chain kind of theory. I've had that for many years since I got into law. Seems to be doing nothing with the case. He's probably doing everything that will be relevant to the strongest points of your case. I don't know this person, so I can't say for sure, but he cannot get paid and his firm can't get paid if he works for others unless he prevails for you. I know it seems frustrating, and probably every client can pick on something about every attorney, including my own, they want things from me that I'm not giving them sometimes. Usually it has to do with, wanting to talk on the phone every day, and that's only a small handful. But again, he's going to be doing everything he needs to do, I believe, because he won't get paid if he doesn't win for you. So just try to hang in there, and he doesn't do do it the way I would do it, at least not with the 2 year thing. That's the only thing I know here specifically you said. And by the way, you said 2 years to go to the last 2 years. When did you become disabled? If you became disabled 2 years ago, SSA will review the stuff from before that. Like they'll even order it a year or two before your alleged onset date. Because they too like to see a little historical perspective. They just don't want to read 1,000 pages of stuff from 15 years ago when you continued to work another 10 years because you weren't disabled. You just had the startup of impairments. Some impairments, the history is not going to be important. And I can't even go into what they might be. It might be that you had some, like if you don't have any repercussions from something that you had surgery on 10 years ago and it's 100% now, then you don't really need to worry about those records because you don't have an impairment in that. But if you had, say, ankle surgery 10 years ago, and you have to be very ginger with your ankle relative to, someone, or when you didn't have an ankle problem, even though you can get around and it's all good and you don't need another surgery, it's never been 100%. Honestly, I would follow up with that ankle and I would get that in there, because if the ankle's not 100%, there are some jobs that you have to have really, really good ankles for, particularly ones where you do a lot of walking. So that might nick out, some light jobs that require a lot of walking. Potentially. I digress, but Anyway, I hope that helps, Muley. I do feel bad for you, only because I know it's really bothering you. I could tell, or you wouldn't have put it up. But he has every incentive to help you and to win for you. In the bottom line is he has to win for you to get paid. Okay, Jeffrey Taylor. Hi, Jeffrey. I had my medical exam on January 24th. Okay, the appointment was at 12:15, and I was in and out in 13 minutes total. I'm an expedited claimant. Due to 100% P&T, exam was basically a range of motion test. And I assume you have limited range of motion, right? That was revealed at that exam. I don't see a question here, but yeah, sometimes these CE exams are so quick that it's kind of a joke. Unless they just ask them to do a range of motion test and the background doesn't matter and your complaints don't matter. I don't know what they asked of him. I don't know if they actually do it that way. But yeah, that's pretty fast. Kind of sounds like our regular medical profession these days. I don't know if this is for me, Rip. Is this for me? Or this is for the ALJ asked the vocational expert a hypothetical question. The vocational expert said there was 3 jobs, then with a limitation, silver wrapper was the only job given. This is 128.25. Can ALJ use this? Yeah, he's going to look at both hypotheticals because it sounds like there was one hypothetical with 3 jobs and there was one hypothetical with 1 job. Once he added in, changed the first hypothetical by adding in a limitation, it is possible that the 1 job would not produce significant numbers in the economy available, existing, and that one wouldn't be enough to deny you if you had the RFC of that second hypothetical. But what if the judge finds that you matched with the hypothetical of the first? You'd like to think that if the judge then asked the second one and stuck the limitation in there, that he's going with that limitation, but it's not always the case. Sometimes they ask several hypotheticals and they still go back to hypothetical number 1, which was there's 5 million jobs. But that's the kind of thing we're on appeal. If that limitation of whatever the limitation was in the second hypothetical, if that limitation is really well documented in the records, then I would, when you get the decision of denial, and I'm not saying you are getting a denial, if it was a denial, I'd be looking for where the judge addressed the limitation and where he kind of discarded it. If he doesn't mention the limitation at all and you have your records and you go through them, then I would be appealing to the appeals council by saying he never addressed this limitation that is replete throughout the medical records. Incidentally, you might say, what, I have 1,500 pages of medical records. How am I going to go through and find that particular, I have to read all 1,500 pages? Back in the day, yes. But if you have a software that does OCR, optical something recognition, optical character recognition. Some of you tech people might know better what the full name is for OCR. I have it through my Adobe Acrobat Pro. I can OCR anything, any PDF. I have many complaints about Acrobat right now, but that's not one of them. But there's other softwares that will OCR. So I would say you get that document OCR so you can do a search for the limit. If the limitation is, I don't know, painful fingers, a finger problem that wasn't included in the first hypothetical, but it's included in the second one, and that reduced everything down to 1 job, I would go find, put in finger. I'll do it. I'll be like finger. I'll do hands. I might even do, and this might produce too many results and it's going to be meaningless, but like LUE or RUE or upper extremities, upper extreme. I don't even do the whole word in case there's various endings. And that's how I get to all those references, some of which will be irrelevant. Like when you put in arm, they're going to have, every time they took the guy's blood pressure, all those are going to pop up because I would say right arm or left arm. So you just got to do it the way you got to do it. But, it's a very nitpicky thing. But OCRing your documents, yes, you need your whole set of medical records that the ALJ has, and you need to OCR it, in my opinion. Jeffrey, is the length of that 13-minute exam a problem? You won't know until you get the results. Like I said, if they were just there to take the range of motion exam, that takes just a few minutes, then I guess that's all they needed to do. And that sounds like the SSA just wanted to confirm that indeed you have such limited range of motion because maybe your doctors hadn't checked it recently. And they don't know how it is now. You can't really read the minds of it. Don't really know. It may or may not be a problem. I feel like not for your particular case, since you said all they did was range of motion. And you said they took pictures, right? That's interesting. And you don't mean Xrays, right? You mean, okay. So it's possible that isn't a bad side for you. For other people, if they have more general, like fibromyalgia, general arthritis, and then there's this really super quickie thing, I don't know. Maybe I would have a problem with it. I don't know. All right, Dwayne Price, nice to see you. Thanks for coming. Sin, I love Texas. We always wanted to move there, but I don't think we're going to make it. 60-year-old stroke victim. Sorry to hear that. Adjudicator called me. SSA doctor wants X-rays of knees to prove arthritis claim. Okay. A adjudicator said, if the doctor sees arthritis, they will go ahead and approve my disability. Yes, that sounds very promising. And incidentally, don't you have X-rays that show the arthritis already, or MRIs or whatever? Like, why do they need that? Unless you've been one of those people that just didn't really go much, so they're doing you a favor here. That could be good. And if you know you have those knees that are going to show up on an X-ray, hopefully it's something that shows up on an X-ray versus there's many impairments that maybe wouldn't show up on an X-ray. But I think with knees, a lot of it does. Okay. Fingers crossed for you, Dwayne. Here we go. Milena, hi, good to see you. You were awarded disability and was found not to be able to perform as a respiratory therapist in 2021. However, I went back to work in 2023, working PRN. I think that's as needed, right? I know my mom, nurse, sister, nurse, PRN. Under the same job title, is that not allowed? Let me just read that again. I was awarded disability and was found not able to perform as a respiratory therapist in 2021. However, I went back to work in 2023, working PRN under the same job title. Is that not allowed? I really don't know what you mean. Like, is that not allowed? You can always go back to work. Whether that interferes with your claim that you can't work substantially depends on how much you go back to work. You know, was it SGA and for long enough? Because remember, you have that trial work period. So, you know, PRN can be, I've seen my family do PRN 4 days a week, 12-hour shifts. So PRN doesn't necessarily mean rare, you know, a rare shift here and there, you know. And I know with, depending on your rate of pay per hour, that can really bump up into SGA. So you need to check that out. If you were, as PRN, were you an employee or a contractor, that can make a huge difference too, because if you need to reduce that income because you were over SGA, because you can potentially use IRWs as a self-employed person. Well, actually, you can do that as an employee too. Business expenses, though, when you're self-employed, you can always have that home office. You can write off mileage, all that to help bring down your. Okay. Oh, good. Crystal K, thank you. Music was playing, and you saw that little sign, I guess. Awesome. See, I'm figuring this out. I'm getting it. Jeffrey, you're 59 in 9 months. I'll tell you something, Jeffrey. I have difficulty remembering which details apply to which person. So I'm not sure which all details applied to you when we just chatted literally 5 minutes ago, because I'm rolling through these fast. Okay, M. Williams, you're going back to M. Williams. Your wife is on SSI, last worked in 2016, filed, but then never heard anything from them. Okay, I'm having a hard time tracking you. It sounds like they said neither one of you, she's on SSI. Maybe you last worked in 2016 and you filed, but then you never heard from them. But were they the ones that told you that you can't file? It's a little disjointed. I'm sorry. The forum here is good for questions that I can ask on one read versus when you put something up and then it's down below in pieces, because I can't spend the time, you know, I can't just keep scrolling up and down trying to find stuff. Okay, let's be rocking. I'm on SSD for mental health, 2 years. Need a divorce. Oh, I'm sorry. Ugh, that's tough. Denied legal aid assistance, so I'll have to try to work to get dollars for the big D. I got a job, start Monday full time. Will this start yeah, for sure. Yeah, that'll start you're going to be making more than the 1,100 and something that's TWP. Now, I'm just curious. This is totally separate and aside. Are you sure you want to start paying for divorce, or just want to do it uncontested? Consider that, like a lot of people do. I mean, if you're loaded and you guys got to split stuff up and you can't come to an agreement like that's fair to you both, yeah, I get it. It's going to go to court. But that's a hard thing to do when you're on limited income. Again, unless, of course, you have huge wealth in the background and you can just draw from it. But you're saying you have to go to work to get a divorce. Just make sure you're sure that you have to do that. When two people who have very little by way of wealth then decide they're going to fight for a divorce, I'm sure you're not doing this, Rockin', but just put it out there. I used to do divorce work in another lifetime about 30 years ago. Now I'd see, you know, I wouldn't even take a case where the two people who barely have anything just want to duke it out. Now, of course, if there's kids, that might be what they're duking it out for. I don't know. It's horrible. That's why I never did it again. I never would. And I don't know how divorce attorneys do it. And I have to pat them on the back if they're doing it well and doing it ethically, because it's needed, but there's so much dirt and garbage and nasty stuff in divorce law. Terrible. Okay. Is the ticket to work, Mary Moore Atkins. Hi, Mary. Good to see you. Is the ticket to work a trap? It's not a trap. Because, and remember, don't mix up ticket to work with a trial work period, guys. Two totally different things. Ticket to work, and I'm just going to speak really generally. You're probably going to want it. The SSA puts out webinars, free webinars on this all the time. I'm always getting emails about them. So you should pop in and get into some of those so you can learn more about it. Trial ticket to work program is for people who feel they could go back to work full time and get off of their benefit. and go back to work. That's their goal. And so while you're in it, you're kept safe while you try in some sort of fashion. But so it's already by design for those that are trying to get off of SSD. It's not for those that are like, I will never be able to work full time, and solidly make SGA where I don't have to worry about going back to SSD. It's not really for those people. And they don't really pretend otherwise. I mean, yeah, I'm sure they make it all glossy and pretty and stuff. And I'm not sure if they actually say the risks. And the risks, of course, are that you work full time and you lose your SSD eventually. But it's designed for people who want to get off SSD. So, go for it. If that's what you want to do. If that's not what you want to do and you just want to work, then just work. Stay within the rules. Find out what they are if you don't know. Try not to make sure you got good information. And it's generally not a problem if you continue to be disabled and continue to treat for your disabilities like you should be. Okay. Jeffrey Taylor. Oh, your ROM is limited. I had back surgery 20 years ago. Knees grind. 20 years of running on steel decks kills your knees. Then you're currently working up all those body parts, right, Jeff? Going to a back specialist, not your PCP, maybe sends you to physical therapy. Knees grind. You definitely want a knee specialist. That's a particular kind of orthopedist. Orthopedists do have subspecialties. So yeah. Go strong. What do they say? Go hard or go home. Really go to town on your, your age is good. So it sounds like you would have a good case. I think you said you were 59 in 9 months or 10 months, if I'm remembering, versus somebody else. Okay, Sadaka. Oh, God, no, it's part 2 of something, and I don't have part 1 in front of me. Sadaka. I remember it was about the husband. Oh, is this the one where it's missing in action? He was denied in 2020, he was diagnosed with non-Hodgkin's lymphoma. Okay, but he didn't try to apply again until last year. Yeah, when is his DLI? Sadaka, if the appeal from 2017, that's moot. That's over. He accepted the denial, and so it's kind of carved in stone. 2020, he was diagnosed with non-Hodgkin's lymphoma, but when is his DLI? If the cancer came at a time, when he became disabled by the cancer, if it's at a time after he no longer has the insurance because he didn't keep buying it, meaning the SSD insurance, then he isn't eligible for SSD because you can't make a claim for insurance you never bought. I always give the example, I buy 6 months worth of car insurance. I don't have an accident, it's just money out the window, as some people will say. And then I really don't want to buy anymore because I didn't even use it the first round. 2 weeks later, after the 6 months is over, I get in a car crash. If I try to make a claim against the insurance company for the insurance coverage from the prior 6 months that when I had it, they're going to be like, duh, no, your accident happened after you decided to drop the insurance. So that is how that works. The term insurance, you have to make sure you keep your term up. Mary, here we go again. Is it true you can return to work and try and keep your SSDI benefits for 5 years over age 55? Those things don't all jive together, Mary, but yes, it's true you can return to work. I don't know what you're getting at here. You can return to work and stay under SGA and potentially under TWP and continue treating for your disabilities that have not vastly improved and be fine. Collect your disabilities and collect your paycheck. I don't know what this other business is about SSDI benefits for 5 years over age 55. I don't really know where that's coming from, so I can't really comment. I am unaware of any rule that, unless it's just the way you're explaining it, any rule that combines those factors in terms of you can go to work. Full-time work is always going to be an end game for disability, obviously, right? Because the definition of disabled is we can't work full-time or over SGA. Sylvia Fuentes, I don't think we've met before, Sylvia. Nice to see you. If we have, I apologize. What to do? Supplemental hearing. Gotta love those supplementals. With medical expert who the ALJ requested. Okay, and the ALJ argued with him because he agreed I was disabled and said I met 2 different listings of SSA. There's nothing you can do. Did you get the result yet? I'm assuming not. Fingers crossed. Depending on where that went, the ALJ might be stuck with what the medical expert says. And it was in a supplemental hearing, no less. So it would be funny if the ALJ completely disregards everything that medical expert says and finds you not disabled. And he's saying you meet listings, which is pretty heavy. That's a strong, good opinion in your favor. RFCs, their opinions on RFCs, that's a little bit more, mushy. Saying you meet a listing is pretty hardcore. It's very hard for a judge to massage that and stick you with a different something, And the fact that the ALJ got the ME means the ALJ recognized that he was not equipped to make a listing determination. So if he then disregards the person who is equipped, I think it would be a totally appealable issue, but I think it might just work on your favor. He tried. He tried to get you denied, perhaps, or maybe his argument was just to really flesh it out, so that if he still gets the results of listing, maybe that's what he wanted the judge. Maybe he knew his arguing questions was going to still produce the same listings, and he will have done his job to be a neutral part of the process so that he will have more of a chance of being not overturned on audit after he awards you. We don't know, right? But it is good if the ME found 2 listings. That's it's not really good for you, your body, but it's really good for your case, by and large. We'll see, and fingers crossed. I think, we never say never, but that's something that's better than if he just denied you after, the first hearing. All right, Rockin. Regarding trial work period, is there anything I need to do other than notify SSA that I am starting work, then turn in wages? No. They might send you an 821 if you're going to be a W-2 asking for the details of the work, what kind of work you're doing, They might not, because if your wages are going to be above, I don't know. Yeah, just keep them notified. I just hate the thought of you risking your disability for a divorce. You're losing a spouse who may have been a contributor, we work together to keep the roof over our mutual heads. 2 live as cheap as 1. And then when there's only one, that one person has to produce all the finances to cover it. I just hate to see you risk your SSD. You got to do what you got to do. What's in your, right? So good luck with that. Just keep them informed. Oh, it's a mule deer, muley. Okay. The pick is I don't know if you guys can see this. I said it was a buck. I was clearly wrong. Well, it is a deer. So would it still be a buck, muley? Right? A stag? Can a mule deer, that's a boy, and I assume that's a boy with the horns, maybe? I digress, but it's kind of fun. Okay. Black Reaper. Yeah, we talked about this, didn't we? Of course, I take clients from Massachusetts. There is no state. Put it this way: the categories we have to sometimes that get filled up and all that other jazz. Sometimes it has nothing to do with what state you are in. 0. I take all states, including the non-continental ones. Let's be rocking. Let's see. Yeah, I don't really have any thoughts on that. Not at all. Never even looked at it. Sorry. Rockin. Rockin asks your thoughts on WIPA, WIPA, Work Incentive Planning and Assistance, or has anyone utilized their services? Is that like a ticket to work entity, or what is it? Is that like something that the SSA uses like within their ticket to work? I don't know. Not my area. Hi, Mac. Milena, this is a follow-up to your initial question. Under my current title, it's different. I'm a respiratory therapist, but now I do pulmonary function tests. The type of work you're doing is going to be the same probably skill level, whether it's respiratory therapist, pulmonary function testing. So I don't know that the nature of the work is going to be between the 2 jobs, relevant. If you're doing the job, and I forget, was your prior job, was it a RN? It's really going to boil down to, did you work SGA more than, you got out of TWP, then you did SGA. So if you were doing this for a long time, obviously that's where the problems arise. And the question is there ways to reduce that? That's just something that has to be gone through with a fine-tooth comb. But I don't think respiratory therapist versus pulmonary function tester is going to make a difference. It's similar work, the same work in terms of skill. It's high skilled. There's no way to get around that. Black Reaper, what are you saying? I'm on my second application and was denied on my first application at the ALJ level. I am going back to the ALJ for some PS reason. Would there be a possibility I could get them to reopen last app? Am I saying no? Unlikely. However, I think I want to say SSD applications for very, very severe and obvious reasons only, they can reopen them up to 4 years later. This is my recollection of old research that's probably 15 years old, but I don't know that it's changed. However, it's not just going to be like we think that ALJ did wrong because we're going to give them another attempt to appeal the ALJ hearing. You have the opportunity to appeal the ALJ hearing and go to appeals council back when you were denied. Your letter of denial actually told you how to do it and gave you the time frame. So if you didn't do that, that ALJ decision is generally carved in stone unless there's some sort of fraud or something crazy going on. I'm going back to the ALJ for some BS reason. Your second application, you're at the ALJ level with your second application, and it's the same ALJ that denied you on your prior claim. Yikes. I don't foresee a reopen, but you don't know. I don't know your case. Those are rare if it's an ALJ decision. Now, if you were denied at initial and recon, it's much more common. I'm not saying it's very common necessarily. I don't even know what the stats are on that. We get them sometimes, you don't always ask for them, unless there's a real reason. Usually missing evidence from back then that is now shown up, but it applies to that period. Sometimes that can be a reason. Black Reaper. Sorry, I can't find someone to take my case without seeing what kind of evidence I have first. Well, go get your evidence and show it to them. Order it. Do what you got to do. Did you say you're in the middle of a case? I don't want to. Yeah, you are. You're in the second of it. And if you're at the ALJ level, the ALJ has all your evidence. So ask them to send it to you. They usually send it on a CD, which is unacceptable to me since most people don't have CD readers and the CDs rarely work. But they can also, I know they can email them. It comes in a very ugly set of emails. It comes in pieces and it's secured, so you can't even combine them unless you're going to separate every believe me, I've done this for my paper files they have paper files sometimes. It's a nightmare. And they have to email me a copy of it. And it's funny, why is it a paper file if you can actually email it to me? It sounds electronic to me. Put it in the electronic file system. But you can get a copy of your medicals if you're at the ALJ. That's not hard to do. What's hard to do is if you're trying to get an old application that is not in front of the current ALJ from the SSA. They balk and kick and scream and try to charge you like your firstborn child and all this stuff for you to get a copy of your old application file, meaning with everything. It's a bit of a nightmare. I think it's inappropriate, unethical, and violates their own rules. And I don't see anybody doing anything about it. So I do request them sometimes. And sometimes I get them, sometimes I don't. And it's not fun. Mac. Okay. I applied for EXR. That would be expedited reinstatement, everybody, I believe he's talking about. And provisional a month ago. I was told the provisional paperwork went to the processing a week ago. Okay. So after 3 weeks. Usually, how long does it take to process payment? Thank you. Love your videos. Oh, thank you. I don't know because I don't see this enough to actually take a gander. It's supposed to be expedited though and provisional. So it's supposed to happen pretty fast. Everything is so slow the last couple of years. They're understaffed and there's been a hiring freeze for a couple of years now. So, and then now it's going to be at least a few more months at the very least. I don't know. I don't think it'll be long. I think they make those a priority. I mean, it stands to reason. The whole reason that you're eligible is because it's expedited reinstatement and provisional because you need the money. So I can't give you a pinpoint, but I think, and I wish you the best that it'll be as soon as it should be. Okay. This is going back to RIP DT. Okay. It was about hypotheticals. There were two, if I'm remembering this correctly. One gave 3 jobs. This is at ALJ hearing. Then the judge added in a limitation that I guess it was a remand case to this judge again, and he added in a limitation that the appeals counsel said he had to add in. Now, keep in mind, Rip, they probably said he has to consider the evidence of the limitation. Doesn't necessarily mean he has to find the limitation. He just has to explain why he finds it not to be a limitation, I suppose. So it's not carved in stone that he's, I do tend to find that ALJs on remand award when they've been, I don't know. I don't know that I've had one that didn't in 20 years. Although I know other people say otherwise. So I don't know about the stats on that. And I think you said that the ALJ argued with the was it? Oh no. That wasn't the one with the ME with the limitation. That's a different one. See, when I try to bounce back and forth, I'm mixing up all your cases. That's not good. Oh, Dwayne. Yeah, guys. So Dwayne, he's talking about a consultative examination. His knee x-rays of his own were 12 years old and they want new x-rays. Heck yeah. 12 years ago, you weren't disabled. So yeah, you want the new x-rays. So that sounds really promising. Assuming you have the arthritis that you've claimed apparently, and they think that your goods are otherwise good. They just want to get that last confirming thing, which is good of them because that helps make sure they're not going to be flipped over on audit. And then you are up Chit's Creek. That's CHIT, guys. I did not curse. Okay, Mac, we did that, right? Okay, let's be rocking. I get it. That's a hard divorce. I feel very grateful. I have a very wonderful husband. Virginia Gomez, how are you? Nice to see you. 51, I expedite appeal was turned over in 1 day, went to court for non-medical. All right, so these aren't numbers, these are words. Yesterday, step 4, still reviewing is maybe what you meant to say. Non-medical, and day 2 denied. Did I pass medical? You were denied on non-medical, or that's when you learned about a denial? No, I suspect you were denied you were denied on the medical. You were found to be not disabled. Went to court for non-medical? Now that doesn't make sense. We generally don't do that. So I'm going to pull back what I said. What kind of court did you go to? I don't understand. Sorry. But I see you commented down here, Virginia, the SSA.gov, the website, you can go and check things, says you were denied. Yeah, and usually that would be a denial on medical. If this is an SSD claim and not an SSI claim, it's usually on medical. If you have SSD, you don't really have to prove anything else by and large. Just that you're not like a illegally present in the country. You're not a fugitive from the law for a crime. So it's kind of like a formality check. So if you were denied, I expect that you were denied on the medical. You just still didn't pull it up. I have to say, guys, when you are denied on initial and you appeal, if you just use the same evidence you had on initial, you're going to get the same result. I mean, it stands to reason, right? So your job on initial, after you apply, is to keep going for that medical evidence and reporting it to the adjudicator for all your different body parts that have issues, in my opinion, not just the one that took you out of your old job. And I always say, look at a body chart and look at whatever body part does not behave as well as it did when you were 20. That would be strength, speed, stamina, and comfort. Any of those not feel the same? I mean, if you're 40 and above, I can't imagine. There's exceptions, but they're not filing for disability. The other body parts don't feel something. And you're 51, Virginia. So hopefully you've been putting in all those, getting follow-up. Doesn't mean they're going to do surgeries or anything, but follow-up, physical therapy if need be, all the things that come with treating an impairment like you want it fixed. Okay? Alrighty. And if that was recon, your next step is ALJ hearing, right? Let's see. Hi, Matthew. On the SSA 3368 disability report, adult form on question 6A on page 6. Can a claimant for SSDI that has a DLI in 2027 and an AOD in February of 2022, but is filling out this SSA 3369 form today, put down the jobs? I'm learning here, Matthew. I need to scroll down. Can they put down the jobs they had 6 years preceding today's date? Oh, I think you had mentioned this before. Like, at what point? I know it's confusing, right? And I sent you that link, but to where they say your DLI is in the future. So when the DLI is in the future, and I think it's on that link of that, and I know it's in one of the videos, guys, when is the 5 years going to scroll back from that they're going to look at? If your DLI is in the future, it's whatever day is currently adjudicating it now. So if you're on recon today, they're going to be looking at 5 years ago. Now, when they're asking you, I know they give a very broad question, Matthew, and I was thinking about that yesterday as I was working on one of them with a client. I'm like, yeah, Matthew's right. I see that it's kind of broad. It just says, give the last 5 since you became disabled, right? Before you became disabled. So yours would be AOD 2022. You're thinking, oh my gosh, I have to go back to 2017. I think on that link, it says and I don't have it in front of me, but when the DLI is in the future, it's the point of the adjudication. And if you're on recon right now or initial, I think you're starting initial, right? It would be now. Now, you still have to follow their rule. I mean, you could try to fudge with them. They'll just probably ask you for more accurate information. If you just give the last 5 years, that might work. I just don't know why they didn't make that. I don't think they fixed it on the new June 2024 work history report, 3369. I think it still says the 5 years before you. I think it's because they're trying to cover all the bases. Because if they say there is some cases, and I think it might be when a DLI is in the past, I think, where it is going to be not 5 years earlier than today, but 5 years from an earlier date, maybe when your DLI ended. But that doesn't apply to you, right? Because you're talking about 2027 DLIs. I mean, in the end, they have to look at the 5 years before the day they adjudicate, I believe, for this. Look at that link I sent you and just double check. But so I guess you don't really want to put more in than you have to. I get it. I mean, if you're worried about it, just put it all in. They can't consider it, right? If they, and I'm trying to think if there's another reason for the work history report why they would do that. They're not really looking for incomes. I mean, you could see where it gets you, I suppose, and just put in 5 years earlier than today, at your own risk. I mean, it's something I'd probably do. And then if they're like, you didn't include, I'll be like, so sorry. But since I can't consider the older stuff, I don't know why it would matter, right? So you have a very good point there, Matthew. You are one of the smartest little cookies, I tell you. You come up with the most intricate of questions, and you're definitely a person who pays attention to detail. Kudos to you. Valerie, good to see you again. I did get letter of approval for disability 2325. It was retrograde to date I originally filed 223. Yay! It actually says on my SS online account, my original SS has been changed to disability 223. That's what we like to hear, Valerie. Thank you for sharing that. That's awesome. Sylvia. Okay, the supplemental hearing, Sylvia was talking about this before, was also including a remand case ALJ denied. The federal court sent it back to ALJ due to ALJ not. Yeah, so then all those, if you have a current claim that you filed anew while you're waiting for the federal district court, who did you a favor, not really a favor, that was their job, held in your favor, your new application, if that was you that had a second application, and your old one that's been remanded, those merge. So, okay, good luck with it. We'll see. Yes, Matthew, in the Palms, the look back of 5 years for past relevant work they do refer to the adjudication date if it's not in the past, right? That's that chart I think you're talking about. Valerie, what are you saying? Would that be something that the difference dollars-wise could be recouped from that time? I'm not really sure what your question is, because you had said, I mean, you're going to get back benefits. Is that what you're talking about? I don't really understand the question, Valerie. I'm sorry. I know you won, though. I hope I touched on your answer. I know you posted it a couple times here, but maybe because that's probably before I answered you. So Valerie won her claim, and she's saying that SSI is pending for approval. You said that you won your disability back to the date you alleged. Is that correct? So if the date you alleged, you had an SSI claim in at that time, Valerie. So that depends if you filed in June of 23 and they found you disabled back to, you filed in June of 23 and they find you disabled back to January of 23. You didn't file till June. You filed a concurrent claim, SSI and SSDI. The SSD goes back to 1/23, but you got the 5-month wait. The SSI didn't get filed until June. The SSI will not be payable because you are having SSD for most, all, or potentially all of the months that you would have been eligible for SSI because you're disabled, and that's assuming you're poor otherwise. Because that SSD, unless it's extremely low, is going to boot out the SSI for all months after your waiting period is over. So let's just say that was June. I don't know if that makes any sense. SSI is a good little I'd say a little back plan for some potential extra bucks that are on the table, but it's not going to work out for everybody with a concurrent claim because it's all going to depend on the dates when you filed, the dates when they find you disabled. So there is that. But I say, why not throw in the SSI if you were otherwise poor enough? Because, hey, it could be an extra almost $5,000 in your pocket. That could pay the attorney fee since it's extra on top of your other back benefits. Well, fingers crossed for you, Sylvia. The ALJ might just come through. Keep us posted, though. I'm interested. Okay. Virginia says that she thought she was good, meaning awarded, because she got a non-medical review. Virginia, I have 3, 4, or 5 videos on the silliness of these messages about going to non-medical review because they're sending them to people who lose and people who have been awarded. And so there's no discretion. And it makes no sense because I know they're not doing a non-medical review to see if you're insured for SSD if you fail, quote unquote, failed the medical. And that's a harsh way of putting it. So I apologize for using the word failed. But so I don't think it actually is. I think they're mismessaging. We watched about this for about over a year now. I know it was like late 2023. I feel like when I first noticed it and people were coming to me like, I got this. And I'm like, oh, that sounds good. And not so much. Okay. Valerie Woodson. Benefits from ex-spouse was brought up for potential claim at the same time as SSD, SSI. Do I have to file for that separately? Ex-spouse benefits, at most you're going to get, if you're of the age where you can even get them, would be 50% of whatever his PIA is. Is your benefit bigger than what that is? Then you're not going to want that one. And yes, if you were eligible for it and you didn't have your SSD, not get it out, SSI is always going to look for Social Security of any kind. Because any monies available to you through Social Security are counted because you could take it and you don't need the welfare. Love it, 609. My SSD has finally been approved. So glad to hear it. Stay on top of all the rules to make sure you keep it, okay? Assuming you remain disabled. If you improve, which I would prefer that for you, and can get back on your feet, that would be great. But in the meantime, if you don't, then you're not able to work. You need to keep your follow-up, keep your evidence reasonably strong for the next CDR, right? You're welcome, Virginia. So 9, I occasionally have popped in. I don't know Walter personally, but I have, that's not HNOT, I think is the last name. He is fun. I do enjoy, we have totally different missions, obviously, here. But yeah, he brings up a lot of current events, and he explains a lot of the political meanderings. I don't always agree with him on those, but often I do. And yeah, it's pretty cool. Jonathan Ginsburg, the other biggie, who is a friend of mine. Okay. Back pay, dollar-wise, would it be recouped? Could be recouped for differences paid for just SS, and now what? Valerie, are you collecting Social Security retirements? Then yeah, you're only going to get for the months that you collect Social Security retirement, early retirement. When you have now proven an SSD case, you get that little bit of extra that they were depriving you of with the early retirement. Okay, so yes, that will be recouped for each and every month that you are disabled and due a disability check. in hindsight that you collected early retirement. They will make up the difference. And then going forward, of course, you get the bigger amount, which is the beauty of why 62, 63, and 64-year-olds, and potentially 65-year-olds, and potentially even older, well, with a 12, and not so much, well, maybe 65 and a half. I don't know where the cutoff would be where you're not going to get anything even if you prevailed. But yeah, if you can get a boost, just go through the SSD process. If you're already collecting early retirement and you're kind of satisfied with it, it's going to be far less stressful probably to go through SSD because you already have the money coming in. Just not as much. You only have like 70% or something, but you want to make that up to 100% because it lasts for the rest of your life instead of being stuck with the 70% for the rest of your life. Thank you, Sylvia. Let's see. Tamika. Hi, Tamika Grundy. Nice to see you. I don't think we've met. The adjudicator told us she sent it back to medical review after she told us she made a decision. Yeah, that's a little slick, right? She did not tell us what the decision was, though. Why would it need to go back to medical review? Again, there's nothing to review if she didn't award you. But they send the messages out, and that's probably what her little script tells her she has to say. They send those. If you look at your online account, Tamika, and let me know what it says, you might find that it says in medical review, but it's not going to say you were awarded. It's very frustrating. You guys have heard me. Matthew, yeah, okay. He says, I think you're correct, Stephanie, that they probably asked for the past 5 years, blah, blah, blah. Yeah, I think it's probably so. I mean, it's been working that way in practice, Matthew. And under your date numbers, that link I shared with the chart of if this is where you're at, if this is where your DLI is, this is what the 5 years will be for you. That seems to say that too. And it's been working in practice. So DJ Kenny, I'm waiting for analysts to look at case according to attorney. Okay, that probably means you don't have an adjudicator. People use different names, different offices use different names. We have adjudicator, claims rep, examiner. I suppose you can use the word analyst. All mean the same thing. And you're at the DDS. That's the stage where they do the medical workup. And a lot of cases are in limbo because there's not enough adjudicators. They haven't been hiring for, I don't know, a year or two. I'm not sure when it started. And there's been attrition where people quit. So it's tough. But you will get one eventually. And if it goes on too long, I just did a video. I don't know if it's out yet, guys. I did a congressional inquiry a number of days ago, less than 2 weeks ago. And we've already had a response. So for a case that's been sitting in limbo for a very long time, we've been throwing in medical evidence so that when an adjudicator comes on board, boom, they got a ton more stuff to look at and arguments to see and, what we're pushing for. But, it's still frustrating the wait. So I wouldn't be surprised if the congressional inquiry by the congressperson that we requested, which he did, because I got a letter yesterday, will prompt this fellow to be addressed in getting an adjudicator. You can't stand over 25 minutes, sit more than 45 minutes max. Any suggestions? And then you have back and neck pains, bad IBS, fibromyalgia diagnosis. DJ, I have a video, I think, on IBS, or maybe it's about someone who needs a lot of bathroom trips. Check it out. I think that could be really important because it's off task time, or it would require an accommodation. And if something requires an accommodation to be a job you can do, that would be bathroom time accommodation, extra breaks. It's supposed to be not one that exists in substantial numbers in the economy in a competitive work environment. So it's kind of a legal technicality. The 25 minutes standing, does that mean you could stand for 25 minutes, sit for 5, stand for another 25, sit for 5? In which case, there's probably plenty of jobs that accommodate that. Same with the sitting. If you sit for 45 max, or maybe even a half hour, if you stand up for a half hour, does that alleviate, and then you can go back down to sitting? In other words, can you rotate those two positions all day long for an 8-hour day, assuming you have the standard supposed breaks of 15 minutes in the morning, 30 minutes for lunch, and 15 minutes in the afternoon? If you can do that, and depending on your vocational profile and age in particular, that ability to do a sit-stand option job could be difficult. If, on the other hand, you're sitting and standing, those are your limits the first time you try for the day, and then the pain sets in, and the next time you can't do it for that long, either one of those, because the pain is just, it's already been aggravated, even though you mitigated it briefly with a little change position. If that stamina to redo those positions gets more limited and more limited, then it almost sounds like you would have to go sit in a recliner and get off the sitting upright, standing upright work posture, and going to recliner with your feet up to get the pressure off the back, the neck would be an off-task position also, I would argue. And the difficulty is getting the proof that you go to a recliner. So it's the kind of thing you want to talk to your doctor about, so maybe it's in the records that you've been complaining about how much you spend in the recliner. if in fact you do. If you are able to do the sit, stand, alternating, and that takes care of the pain and makes it manageable, that won't really work for you. The fibromyalgia always kicks in another element there. And IBS, like I said, I would check out those video on, I don't even know what the tag word is in it, but it wasn't really that long ago. The bathroom, having to take a lot of bathroom breaks. It really wasn't that long ago. I want to say it was probably in the last month, maybe two. It might have the word bathroom in the title. Usually that's how I try to search for them. What's in the title? Hey. Okay, Virginia says, I don't know how I didn't pass medical if I have more than 6 listings in the blue book. Shaking my head, and I've been fighting since 5/22. I'm like, why SSA overturned my appeal in one day if I didn't pass medical? You probably didn't give them any more evidence. On your appeal form, Virginia, since they did it in one day, which is crazy, did you say everything is the same, nothing's worse, nothing's improved, and I haven't gone to a doctor since I applied? Look at what you said. You might not have meant to say it, but look at what you said. Sometimes people think if they don't have a new doctor, they don't put anything in about ones they continued to see, because I already gave them those contact information. Yeah, but you said that you saw them 6 months ago. You didn't say you've been seeing them now. So that might be maybe an error. And another thing I want to address, guys, and this is for you, Virginia, if I have more than 6 listings, you're not, I'm going to say this is going to sound cold, guys. We are not, you, me, lawyers, claimants, we are not the deciders if something meets a listing. Some people think that just because something is listed in the blue book, then they meet a listing. No, it's all going to depend on whether your medical records pinpoint everything in that listing definition, the criteria. And of course, we're not really, I mean, we can suspect we do. We feel like we could connect the dots and stuff. But, you know, I get the sense you might be saying, I saw fibromyalgia in the listing, which that probably wouldn't be in there. I saw that there's a listing for back impairment. I have a back impairment. I made a listing. No. That listing, look at the details. It is intense. And they made it harder, like, I don't know, a few years back. So I want to say they were trying to make it harder, like 15, 16. I think it was 17 when it became effective, the very beginning of. So, you know, when you think you made a listing, that doesn't necessarily mean you made a listing. Just because your impairment can be a listing, is listed as if you are the severe version as defined below, then we may find you meet a listing. That's when you meet a listing. Not just because you happen to have a back impairment and back impairments have listings, or a cancer, or I have cancer, therefore I meet a listing. Not so. It's very specific. It could be for so many things, you know. It could be for mental health, anxiety. Some people say I have anxiety. I meet a listing. See, anxiety 12.06 or whatever. No. Do you have those problems? And is it proven in your medical records, not just you saying it? That's what you got to get to, guys. It's those medical records, and how they show the severity of the condition. And Virginia, you don't say how old you are, but if you're under 50, if it's not a clear actual passing a listing, it's going to be, it's that whole extra 9 yards you got to struggle with. It's a hard bar. Valerie, I agree. She's saying that the difference between SS, I think she means Social Security retirement, early retirement, not just Social Security, because God knows there's plenty different kinds of that, right? We've got SSD, we've got survivor, we have dependents, children's, but the difference between early Social Security retirement, Social Security early retirement, and SSD can be substantial. If you took your early retirement at 62, but you could also have been disabled at 62, you took a 30 to 35% permanent pay deduction every month that you're not getting. It's substantial for the rest of your life, unless you can turn it into that, where is it? Woo, SSD right there. And then you can get that flipped. All right. Every little bit helps. I agree, Valerie, particularly when we can't work anymore, right? I mean, we need to have as much as we can to make our worries about meeting our bills for survival, intact. Okay. Matthew, I do love your questions. You're a honey. And you have really good ones. And like I said, you really get into the nooks and crannies. Love it. 609. Is it possible to get back pay from a suspended benefits when you file an expedited reinstatement, or will they just restart my benefits? I'm not going to know the answer. So when you file for the expedited, I think your question is, my benefits were suspended, maybe due to working or whatever. I filed it, a couple years later, I filed for an expedited reinstatement when I was no longer able to work to that extent, same disabilities and all that. They will, if you prevail on the expedited, they will restart your benefits. And it will certainly go back to when you applied for the expedited reinstatement. What I don't know, love it, is if it, I kind of think it might, but I hadn't looked it up. So maybe because I want it to be so, I'm thinking it would be a good idea. Whether it can go 6 months before you applied for expedited. Is there a certain amount of retro? So if you have filed for expedited in February of 2025, because all fall you stopped working and you were just hoping to be able to go back to work, and then you realize you couldn't, so you're going to file for expedited. I would like to think they would do the retro. Because that will encourage people. If there is retro, it encourages people not to file for a benefit the second they stop working, when they might feasibly actually recover. It reduces the amount of applications that are just coming in that are not going to work, because they do recover. A lot of people do, right? And it would make people feel like they have to, even if they think they're going to get better, they have to file and put that strain on the SSA system, because what if they can't go back to work? What if something happens, they can't go back to work? What if it's more serious than what they're admitting to themselves? So I think that is the purpose of retro for SSD, that you can go back a bit. We know that for SSD and a normal claim, it goes back 12 months, potentially, if you were disabled that long under the rules. Is expedited the same? Love it. I can't say. I haven't looked it up, but now you're making me want to look it up, so I probably will do that. If anyone else happens to be like a keyboard wizard and wants to see if they can find the DI or the POMS or whatever explains if that's so, or the CFR, feel free to share it to me so I don't have to do it. That would be great. I promise I'll share it to everybody. All right, this is a question that people ask all the time. Should I apply for SSD and SSI on my own, and then if I get denied on initial and recon, then get an attorney? Some people say it's not worth it to get an attorney early on because there's not much the attorney can do for the initial application process. Okay, whether you should do that or not, I'm not going to answer. A lot of times it depends on if you can get an attorney, so that's a whole nother thing. But I will say this, and I wholeheartedly believe this, only because I've seen the differences massively. The attorney, if they're doing their job, does a lot of stuff on initial. Huge things that otherwise you're doing, and the results of how you do it stick with your case all the way to an ALJ hearing, all the way through AC appeal, and all the way to federal district court if you take your denials that far. Sometimes I even see them crop up in a subsequent application. Sometimes I see SSA pull, and I resent it a little bit because I'll see them cherry pick and pull something from a previous application. Well, why didn't you pull the stuff that was really good? That was the strongest part of that case, even though that case was denied. Why did you just pull, this, that, other things? I don't find that to be something they should be doing, but I see them do it all the time. I'll see it in like an ALJ file, heading to hearing, like, why are they, that doesn't seem right. If you're not going to pull up everything else, and you're just cherry picking. I think attorneys and I'm going to say this, I think there's different kinds of attorneys. Some do different things on initial. There's some that do nothing on initial. They want you to do the application. They want to send in their 1696 so that they want you to do your application yourself. And then they want to come in after you've done that work. It takes multiple hours for us to get to the point of putting in an application where it's finalizing in. And so, yeah, is it nice to be able to skip that and be like, he did it, and now I can just hop in? I mean, there are going to be cases where I just am hopping in because the person never came to me. But if the person comes to me and I'm going to take their case, I prefer it before they apply. That way, there's a lot of information in the application where you can really make a lot of inconsistencies that you're unaware of. They will be inconsistent with later reports that are going to be demanded of you on initial. So to me, it's really important that everything cross-checks. Not to mention, aside from the inconsistencies, you might have just said something in a completely terrible way that could be misinterpreted in a way that you didn't mean and that is inaccurate. So there's many ways to explain things, some of which are inappropriately inaccurate and damaging, and others that are not. Sometimes I'll see people put in answers to that the question wasn't even asked. And they throw in this answer was not asked, and it's damaging. I'm like, why are you even putting that in there? They didn't ask you about that. It's like loose lips sink ships. When they're not asking for it, it means you don't say it. So I think, if you're going to get an attorney that doesn't do a lot on initial, that's what you're going to get. If you have, and there's plenty that do plenty on initial, they assist with function reports and work history reports, aside from the fact that they gather the information for the application and they word it in an appropriate way. And then you have ones that don't. And there's probably no way to know. I mean, if you ask an attorney that you're thinking of retaining, do you work? Well, you could, I suppose. I'm just curious, does your practice put together the function report with me, or do you just have me do it when I get the demand? And see what they say. If you can get the answer in writing, that's always good too. So to me, initial is very important. A lot of stuff goes on, but that's not so for everybody. Not to mention, by the way, the attorney should be looking in the DDS online folder. Any attorney who does this kind of work doesn't mean they even do it full time, but if they do it enough, they're going to have access. And they can see if the adjudicator has been ordering your records, or he only ordered 2 out of the 5 you listed. And then he can either call them or he can go order them himself with a, presumably he has a HIPAA that he has you sign for him, like we do. It's your HIPAA. And then we just, we have facilitators that send them out and fax them and mail them for you so that you don't have to worry about that. There's a lot that can go on an initial. And same for recon. I'd say recon possibly even more. Even though you don't have to do the work history report in recon, you usually do have to do a function report nowadays, but a second one. But yeah, Matthew's saying, other people say it's good to have an attorney from the beginning in case you get denied because a mistake in your initial file can affect your appeals negatively. Yes, indeed. Even if you get denied with having an attorney, it could the information can all still be good. They just denied you because remember, initial and recon is more like checkbox people, little robust check-in boxes, right? It's not with the discretion and the ALJs have the capacity and are allowed to really think about the credibility in this and the likelihood of given that kind of medical record, what's the likelihood that, she or he would be able to do this level of exertion, even though it's not spelled out, like they can really use discretion and common sense. And I don't think that's similarly allowed down below, not by the adjudicator. Could the medical expert who designs your RFC behind the scenes on initial and recon? Yeah, possibly. But they're not and they work for the SSA. And while the ALJs are paid by the SSA, they have de novo review and, they're just not as beholden, and they take their job a little more seriously, I believe, and they try to do the right thing by and large. Valerie, okay. Yep, gotcha. 62. When you took early retirement, 66. Yeah, I hope you get it. It'll be nice for you. Okay. Now, Matthew, I know, Matthew, you've been talking to a lot of practitioners or the secretaries or paralegals that work in the offices. Talked to a paralegal a couple of days ago from Florida Disability Laws who said after talking to me for 45 minutes that she thinks I will get approved at the initial, although no guarantee. Awesome. Well, that's great. Are you going to use them? They'll take your case, it sounds like, right? I'd say don't be penny wise and pound foolish. Don't do it on your own. You don't have the objectivity, number one. None of us do when it's our own. You do a lot of research, Matthew, I can tell, but I still think you should use, if for no other reason, let them do a lot of the legwork of like ordering records and stuff, and what about the function report and the work history report? Valissa. Hi, Valissa. I don't think we've met. Nice. Thank you for being here. Okay, I was denied 6/2023. So we're looking at almost 2 years ago. Applied for reconsideration, a year and a half ago. Applied for reconsideration, still waiting and have brain surgery in 2 weeks. Oh my goodness, Val. Will they prolong and wait for recovery? Do they know about it? Do you have a representative? I have seen adjudicators stay a case, but not forever. Sometimes they will stay it a little bit. Can't say that would be done here, but you have to, either you or your attorney have to speak to them. You want them to know that you're going in for brain surgery. Does your doctor tell you how long you have to recover and be genteel and maybe not look at screens? I don't know. I don't know what the limitations will be. Is there anything of that? I don't know your case, but I wish you a very speedy recovery and a successful surgery. And definitely make sure that the adjudicator on your case on reconsideration knows that you're going in. I assume that's the case, but I just wanted to drill it home because some people are like, they think the SSA is out there following, just somehow mind reads and knows that you have, they don't take time to do that. They don't mind read, number one, and they're not following you, number two. I mean, following is surveillance, not like getting into your doctor's medical record to see if you have an appointment coming up. So you have to be the one to tell them, okay? Uber important, guys. I mean, if you have an attorney, you should be telling them and they should be telling the SSA or the DDS. Again, I'm not sure if they all do. Valerie is in the middle of an SSD claim for herself. She's collecting early retirement, but looking for the SSD so that can get that up to the more normal rate. And she has, I think, an ex-spouse who worked for the post office for 30 years and farmed. Wow, he was a very vigorous fellow for 60 years. Should I file? If you file for ex-spouse benefits, it won't hurt you. You still have your other, it's just confirming another eligibility pot to take whatever the max would be that you can take. So you can always file for it. And, if it ends up being that the 50% of his is maybe you're not the highest income earner, it could be that 50% is higher. Let's say he's getting $3,600 a month. Sorry, I think they max is higher than that now. But that would be $1,800 to you. If your own benefit is, your own SSD benefit is, but Valerie, and also you're 66. Yeah, you got to look into that. I would call the SSA. Your own early retirement, usually when you file for early retirement, they ask you about your marriage to see if you could be getting divorced spouse benefits too. So that suggests maybe you are getting the I don't know. You really have to inquire though. Never be shy about that. It's not going to hurt your case. All right, Matthew, this makes me suspicious. So this paralegal at this disability firm in Florida says she thinks you're going to win on initial, but go ahead and do it on your own. If I thought someone was going to win on initial or had a good chance if they had proper guidance, I'd be all over that and say, come to mama. I mean, seriously, you're under 50. You and I have talked about this. It is such a marathon, and it is so hard. Is it possible you could win on initial just like she said? Yes, but statistically speaking, now they don't give us these stats, I don't think. They give us overall initial winning stats, and I happen to think that most of those are not the people under 50. That's just my suspicion. So if 38% win on initial, 98% of those are over 50 and 2%, you know what I mean? I have nothing to back that up with. It's just my suspicion, and my numbers are being very loose here, but that's what I think. So why would she say, we think you can win, but we're not going to represent you, so you can go win on your own so we don't earn a fee? I just find that to be, maybe she's just trying to be sweet, and it's her sweet way of saying she won't. But maybe hold her to it and say, great, I want you to represent me. Then you'll find out. All right. Okay. Tamika, if it's not with the DDS, Tamika's talking about being in medical review. The DDS person said she sent it down and now it's in medical review, but didn't tell her whether it was a win or a lose. The DDS person no longer has your claim at all. I wouldn't even be calling her. She doesn't have your file anymore. She's not your adjudicator anymore. So she's being nice. She's telling you what you need to do, and you do have to wait for that letter, unfortunately. Okay. I know it's frustrating. And the mixed messaging, I can't even wrap my mind around. Medical review. Non-medical review. DJ Kenny, good. You saw the video. Good. Okay. Oh, Tamika, you're saying it's been in medical review since early 2024. All right. I would contact my congressperson. So your adjudicator is not on it in over a year. So that's not even your adjudicator, even longer than I thought. You said medical review. Sorry. Yeah, that makes sense. But you're saying it's not in medical review. You got sent to non-medical review, correct? If she had awarded you, there's also an audit that could take place, but quality review. If it's been medical review since early 2024, if you know that there's somebody working on it, do they ask things of you? Do they ask for updated medicals? And they're working on it, and you just have to be patient. If it's already out of there and in non-medical review, again, you got to be patient. It'll take a number of weeks, probably. Up to. If it goes 2 months, yeah, maybe reach out to your congressperson. We've got to start lighting a match under the slow offices. Right? Okay, Matthew, have you ever taken on a case where somebody had bad knee or bad knees and had to have a meniscus transplant from a cadaver? I don't recall specifically if they had a meniscus transplant from a cadaver, but definitely surgeries. FYI, first one was done in 1984, and patients don't have to take anti-rejection medications? Is that what you're saying? Really? I would have thought any kind of cadaver business would include that, but what do I know? Wow, this is you, Matthew. You are young, pup. Bad knees. Yeah. Be sure to use that in your case, of course. If your knees are, if the cadaver's not working out for you. Didn't know anti-rejection like they would for an organ. That's good to know. It's weird, isn't it? What our bodies do, All right. I'm just scrolling down, guys. My apologies. Virginia, you're asking if you're 51, can you file for your appeal, or do I have to stick with my attorney? You can always get rid of your attorney. We have lots of videos on that. However, there are consequences. And if you're looking for another attorney, that can be tenuous. And there's kind of ways to find, an attorney might come on board they might come on board anyway, but some of them will only do so if you get a withdrawal from your current attorney with a waiver of fee. And the waiver of fee is so that they don't have to split the generally small fee available in these cases with another firm. The other firm, on the other hand, if they've done, substantial work on your claim, they might not want to waive fee, because they don't want to give up, you dump them and they want to get paid for the work they did. So it is a little sketchy. There are videos that explain all of that. I think it might be, if you look under playlists for appointed or attorney or representative, you'll see playlists. And I know it's in one of those words will work and get you what you need to know. I think I did one recently too, actually. Okay. It's almost 2 hours, guys. Darn, this really flies, doesn't it? I'm such a yapper, aren't I? Shayla. Nice to see you. I don't think we've met. Hello, I've been on SSDI since 2013. Okay. Worked in 2022. Deemed substantial SGA from SSA. Applied again for SSDI in 2024. Got denied twice, not waiting on ALJ date. Did you get a representative, or what's up with that? I don't know how old you are either. That'll probably tell a lot. And of course, you might have been able to do an expedited reinstatement since it was less than 5 years, when you filed again, assuming your disabilities are the same general kind of disabilities, right? Have you been vigorously pursuing treatment for all the things that you had before that are still impaired, and any new ones? That's quite a long time. That's a 12-year difference presumably you have, unfortunately, we age and things kind of compound. So you might have more stuff. So it's really important that you treat. Yeah, good luck at the ALJ. I really wish you the best on that. Valerie Woodson, FRA is full retirement age. Oh, thank you, Valissa. Bye, Smalley. Thank you. Okay. Mr. Vincent asks a very general question. How does compassionate allowance work? If you have an impairment that is a diagnosis that is in the compassionate allowance list at ssa.gov, then generally they're going to, as long as that diagnosis is confirmed as an actual diagnosis, not just something you claim. So usually they have to get some sort of maybe quickie medical record on that. They're not going to make you prove your RFC or any of that business. They're going to generally just award you. So it's pretty serious, obviously, if you have a compassionate allowance. But I'm glad they have the listings. Occasionally they add impairments to it. So it is a growing list. Alrighty. I hope that helps. By the way, when you're doing your application and you have a compassionate allowance, I would make sure to express it exactly in your list of impairments. If you put in your remarks, by the way, I mentioned blah, blah, it's a compassionate allowance. Like, throw the words out there because I think they have word grabbing software. And when they see, they probably have, OCR for all the compassionate allowance diseases. I would also go to the compassionate allowance list. And if your doctors use, sometimes diagnoses have different ways, different verbiage. You can use the one, I would use what the doctor says it is. And then if you know that that's the equivalent of this other one, the way the SSA, the name it gives it, because sometimes they're slightly different. There's like AKAs. I would put that in their remarks, like also known as this and this and this. And that'll get their attention super fast. Okay. For grandbabies, nice to see you again. Oh, if you didn't just come in, I just talked about this. I'm assuming that you just said this 3 minutes ago. I personally don't think, I'm biased. I think everyone should use a good representative, attorney or non-attorney rep, one that's going to work on the case and make that initial the strongest initial it can be, so that you might just win an initial and not reduce your chances of winning early. That's if winning early is important to you. Is there fees that you're like, maybe I can escape fees if I just get denied a few times? Well, okay. Everyone has their thought process on it, but I know for a fact cases are much stronger with representation, assuming the representation is decent. So word of mouth is often a good way. I don't know that I would just go to a website and trust somebody's good or diligent or, exclusively SSD. Although if they're exclusively SSD, it'll probably just say SSD on the fields they cover, whereas you'll know if they're kind of spreading themselves out thin when they have a couple of the fields up there, or sometimes some of them have a panoply of fields. So you know that the SSD is the redheaded stepchild of their practice, and you're probably not going to get someone who knows very much about it or can spend a lot of time on it. They probably haven't made a streamlined, there's so many things that they would not have done for something that's not really their bread and butter, But I do think a good rep is worth their weight in gold. And I'm biased. For grandbabies, again, does it cost money up front for SSDI? No, you don't pay anything to the SSA, and you generally, if you get an attorney, you don't pay any retainer for that either. And in the end, you only pay if the SSA finds that you are awarded with back benefits, or alternatively, there could be a fee petition, but the SSA has to award it. So you don't generally have a legal fee for work performed if you don't win your case. So to me, it's a no-brainer. Penny wise, pound foolish to not use an attorney. That's a good one. Again, I'm not going to say across the board, guys. Although, to the extent that they only get paid if they win, most of them do something of value. Although there was always the people that would hope they would take on the case, then do squat, hoping that it would be denied, so they can then clean it up as they're heading towards hearing and get the stuff that should have been gotten before, that shows that you were disabled before, so they can get that old onset date established and they get all the back benefits. So there is that kind of unethical behavior. So that's why I think word of mouth for people who have used a representative can feasibly be the best way to do it. Yeah, grandbabies, generally no retainer. Generally, if you have a regular standard kind of case. Very rare for retainer. It's usually when there's no possibility of back benefits. Jen Me. Were you here before, Jen? You look familiar. The only offices that would take my case was a big box. I'm assuming because I'm young. They were not that attentive, and I only met lawyer week before hearing. Fired after hearing of my Lou lawyers. Oh, well, that's good. Very good. Mr. Vincent, thank you. Very sweet. He thinks I'm smart. I have you fooled, Mr. Vincent. No, I'm just kidding. Okay. I think we're at the bottom, right? Right. Because we are over the 2-hour mark. I don't really know what that means, Virginia. Matthew wants to know if he can have his application expedited if he can show proof that I have a child with autism and other emotional delays and deficits. I've never heard that being a basis for expedition. Usually it's dire need, gonna lose housing, gonna die, those kind of things. So generally not. I don't think, Matthew. Okay. Oh, Valerie, that's very sweet. Thank you. I'd love to be called a treasure. Oh, Virginia, thank you as well. Okay. I want to stop reading the tootings of my own horn here. It's a little embarrassing. Oh, Clara Ross. Does this new thing with Elon Musk interfere with the approval of people going through the process? Not at all. I believe my DDS worker was switched out since I've been waiting for 11 months now to know. Have I heard nothing with regard to any interference or anything. He's really more of a money guy. When he finds money has been spent and not accounted for, that's kind of his thing. You know, we've all been hearing about what we're learning about one or more agencies that have been stealing money blind from the taxpayers. So I'm happy about this. Yeah. Can it be a little painful at first? Sure. Yep. But if everyone sticks together and helps each other out, you know, when you rely on federal taxpayers for assistance in any way, you can't be defrauding, right? These entities cannot be defrauding, and they seem to think that they don't have to show the monies. Are you kidding me? Can you imagine your bookkeeper? You have a bookkeeper and you say, I want to see what's in my books. And they're like, nope. I'm the bookkeeper. You stay out. But I earn the money. It doesn't matter. I'm the bookkeeper. You know, like, I mean, so what? You know? Yikes. Really bad. So you know there's something stinky going on, right, guys? And your DDS worker was probably switched out. That has been all over the place. It's not that they're switched out, Clara. They quit. There's attrition in big numbers. The big resignation, you know, has still been going on. And there have not been hiring. It was a hiring freeze for a year or two now. I don't even know when it started. I know I see reference back to maybe 2023, but it could have been earlier. I don't know. And of course, now everything is kind of frozen for a few weeks at least to see. It's a temporary to see where, you know, where the dead weight is, who's screwing up. And that's not SSA per se. That's, you know, generally, you know, because there's been so much abuse and stealing and theft and mismanagement. And that's why they keep wanting to jack up our taxes. And, you know, just a horrible thing. So I'd say hold on to your hats. I have plenty of people, I'll say, Clara, and I'm very involved in my clients' cases that have had no adjudicator like you for a spell. When it gets really, I try not to be like the Karen of the group and cry every time there's no adjudicator, because I'm not going to be that person with the SSA. But when it goes long enough, I go through the congressperson for my client and I prepare the stuff to send them. And they are by and large excellent. They'll do a congressional inquiry on the, you know, did her case. You know, she says nobody's looked at it since, no one's been in the file since, and we can see this as attorneys. I don't know if you can see it on yours. In 7 months, can you please, you know, just check? And I expect, and I was saying this earlier, I just did one 2 weeks ago or 10 days ago, got a response back from the congressman that said, yes, happy to help. And then yesterday got a follow-up letter saying, okay, so this is what you heard from the SSA. I'll let you know if I get, you know, when I hear more. And the SSA letter was to the effect that it is unassigned right now, but we see there's now a congressional interest. So I'm expecting that congressional interest, which is what happens when there's a congressional inquiry, to put a little match under, you know. So we'll see. We will see. Anyhow, does anybody have any more questions? Anybody? I'm just playing with some buttons here. Put them up if you have them. I'll just stay a little bit longer. Let me check. Hold on, Matthew. I don't want here. That's just too much. All right. So we have Paul. Give me 1 second. Okay. Paul says, I clicked it, right? Just received a letter from SSA from my CDR short form. That's good. It said they were going to review my case, but they are not at this time. And they're not calling my doctors. My diary date is every 7 years. Okay, good. That means they don't expect you to improve, Paul. So that's bad for you, but good for your continued benefits. As you know, I'm kind of the person that's cautious when it comes to something as important as a person's benefits. So I always just do the little annoying reminder that keep up with follow-up with your impairments. You know, if you have switched age categories, you're even that much better off. So if you've changed from 40s to 50, that's helpful in a CDR. If you've changed from 54 to 55, also helpful. And of course, if you get up to 60. So you're probably doing pretty good there. So that's usually why they say those things. Now, remanded case. So Jen Me asked, how long does a remanded case generally take to get to a hearing these days? It's supposed to be one of the ones that are scheduled first. Okay. Things are going a little slow again now, the last maybe 6 months. So, you know, ALJ hearings were kind of trucking along quite nicely compared to initial and recon, but I don't really see that now. I'm trying to think. I'm doing a remand hearing next week. Nope, the week after. I'm trying to think when we got the AC overturned, probably a year ago. So it did sit for a little bit. Maybe it was last spring, and our hearing is in February. So it's not overnight. Of course, I use the time wisely, collecting the medical records, and I'm updating my brief that I had from the first one. And I'm going to also put in, hone in on what the appeals council said the ALJ neglected to do. And I want to make that stuff. If I have any control over how it can be presented in a positive light, I want to hone in on that, because that's the thing that they focused on. I'm looking at a big bird up there flying outside my window. So remand cases, it's still going to take, they still have to give you the 75 days notice, which is useful. I mean, it's useful for me. If they just said, oh, your hearing's next week on a case, I'd be like, what? We have to do X, Y, and Z. And some of the stuff you can't do until you know about the hearing. And it's stuff that takes a number of weeks because of the medical provider. So I like the 75-day notice before a hearing that they have to give. And so usually lately it's been like, so if 75 days is about 2.5 months, usually it's about a 3 month, but sometimes it's exactly on the dime, 2 months. But that's once they notify you that they're ready. The wait is basically on their side to get it, they have a certain amount they can throw onto judges in their docket, I suppose, when it comes on the pike. So hope that vaguely answers your question, Jenny. Virginia, I can't tell you whether you should dump your attorney or do it on your own. I would tend to think you should just stick with the attorney. I mean, and I forget what the details were, why you weren't happy with them. So you don't have to explain it, because then it'll just be scrolling. They have every incentive to win for you. And they might have their own little protocol, and they might know what they do and do not need. I tend to just go full hilt for everything, but everyone's different, and that doesn't mean they're not going to have a very solid case for you. So, okay. I just don't want to see you having it, because are you going to know what you have to do right now? Seriously. And then you're disabled. Are you going to have the wherewithal and the stamina and the energy to not only figure out what you have to do, but then go do it? I mean, it includes sending things out and drafting things. Are you going to be able to do that? That's why I say just stick with them. I mean, unless there's a grave reason not to. DJ, thoughts on handling medications? Some I had bad effects, stopped. Others I didn't get due to research. Not right for me or side effects. Need to update records with the explanations. Well, presumably when you blow off a doctor's recommendation, DJ, you actually make sure the doctor knows, right? I'm not taking the gabapentin because it puts me to sleep, or if there's one that makes you irritable and you're snapping at your family and you're going to lose your spouse, whatever the case is. Sometimes things make people nauseous. And it's funny because then they'll go prescribe you another drug called a Zoloft or something for, I think it's Zoloft, for anti-nausea. But then they give you diarrhea. So then you can have the anti-diarrhea pill. Can't stand it. But if you communicate with your doctor that it's clear why you're not taking a med or why you asked him to discontinue it, hopefully he'll put it in the records. If you have a portal and you're not sure he puts it in the records, or the MA does, or whoever's taking your statements down, consider messaging them formally through the portal about, just wanted to go over the so-and-so guy. I just want to, remind you that that stuff really causes me bad nausea. And so we're going to look for a different, better suitably medication, right? That'll help address my needs, but not make me sick. Put it in there, because if you don't, sometimes it doesn't show up because they're not always very diligent about recording what we say. Hang in there, Jenny. Valerie, they pay the back pay all at once. You're SSD, not SSI. And even if you were SSI, they would probably still pay it all at once, because you would be getting off SSI because of SSI, but I don't think you're getting SSI. Yeah, they pay the SSD all at once because you're not held to a resource limit. You could be a rich woman, right? And of course, collect your insurance benefits that you paid for and worked for, or your family member did. Okay. Matthew says, some people say that the benefit of having an attorney in your local area, I'm chuckling at this, is that they can help you find housing before you get approved for SSI or SSDI, as a lot of apartments are not accepted until approved. That's really funny. Haven't met a single lawyer yet that does that. That does SSD, but that's cute. Good luck with that. Yeah. Maybe they'll go and take you on showings. I'm jesting, but no. Yeah, I don't know any SSD lawyer that's going to be helping somebody find housing. What they'll do, you should have a copy anyway when you get your SSI award. Now you've got your, if that's the criteria that the housing place needs, you've got it. But no, I don't think they're going to show you around. I don't think they're going to research with Zillow.com for rentals or Realtor.com. I just don't think they're going to do it. If you find one like that, that's great. Now if you're on welfare, yes, those are caseworkers that oftentimes are there to help people with that. That's their job. They're not SSD lawyers. They don't know squat about it usually, or they know, little knowledge is a dangerous thing, but they do more of that in the trenches in terms of that, getting someone in housing and all that. They have all those connections. Your SSD lawyer, if he's actually an SSD lawyer, isn't going to do that. So it's cute that someone suggested that, but I think would be a miracle. So maybe 1 in a million? I don't know. I think it's better to get an SSD lawyer that is good, that that you're comfortable with for positive. Again, I still think word of mouth is really good because, again, any lawyer can say whatever they want, including myself. Their website might look good. I favor ones that are exclusively SSD, SSI. Second best would be those that do those, but also maybe do VA. That's not bad. When they start throwing in workers' comp and LTD, and I know my peers might not like me saying this, they're starting to spread themselves thin. Now, that's not to say they couldn't be super, super good, but SSD pays the least. So it's not going to be think about it. It's not the bread and butter. Human nature just says less time is going to be focused on perfecting that whole process that they do. If that's not their thing, it's a tag along. I always say the redheaded stepchild for those that have other children in their law firm, other field. Oh, Mr. Vincent says, has a process for SSDI always been this hard? Yes, it has. Although I will say it was slightly easier. They really made a push in like 2015, 2016 to get rid of the treating provider rule that lets your treating doctor's opinion of how limited you are hold more water, basically, than those ones you see once, like through the SSA and whatnot. That was a battle they did, and they prevailed in 16, and they made it start in 17. I thought it was kind of dirty pool. I don't agree with it. So now, everyone's considered equal, kind of, like in a sense. Like your treating doctor holds no more water than the guy that saw you once. Like it used to be, and I'm not saying it strictly. The judge can find him more persuasive, but it used to be mandatory that if the treating provider has well supported, his records well support his current opinion, and there's nothing really inconsistent with other medical records to say it's not true, then his opinion is controlling. It was controlling on the issue of things like can't walk for more than 5 minutes or whatever. They ripped that out. And that was kind of crushing. So that was probably worked on for a few years before 2015, 2016. But I remember that being the push then, and they succeeded and got it passed. And then they just, like they tend to do, they always put it out a few months, particularly if they want it to be affected under a different administration, which is what they did here. But so in that sense, it's harder, but that just means we work harder. And I don't know that made a reduction in awards necessarily. I don't know. I mean, awards have come down. I know like in 2010, 2011, there was a push by the administration to treat things differently so the awards would come down. This was never an official thing. This wasn't a rule change like what I just mentioned, but colleagues of mine who had been to seminars with ALJs, the ALJs spilled the beans on the panache coming from up above, how they have to do this and look at this a little differently so that there is less awards. And indeed, awards went down after that. I didn't see it for a couple of years, and then I saw mine slightly tweaked down. Although I feel like now, I don't know, it's not, then again, I take cases I know that with work can prevail. I don't take the cases that I think can't prevail, even with hard work on both sides. So there is that, because remember, there's always going to be claimants who don't have an attorney, probably because they can't get one, usually a younger individual. They're all going to apply whether or not they can get an attorney, and their denial rates are probably quite high, is my guess. So Matthew, I don't know where people find out where to get housing. That's based on every single town in the country. So someone will have to memorize thousands and thousands of towns and where their low income housing is, for instance. I would suggest everyone goes to their local welfare office as starters, and they can direct them, because those are the people that deal with that. They sometimes have housing programs. That's a local thing. That's not Social Security or SSI related. They might use an SSI award to say, he's eligible financially for this, but it's not anything that the SSI people, get into. It's very local. And it's local, even more local than state level. It's like county and sometimes town. So every person has to but again, I would go to the closest assistance office, which could be county level. So it might not be in your town, but that's the one that usually has all that information. That's their job, right? When a doctor, Matthew, says it, tells a client, a patient that they're disabled, it doesn't mean anything for SSA purposes. Doesn't mean a thing. And the SSA, in fact, will not even embrace it. In fact, they'll have a clause that says, I'm disregarding what this doctor says because his opinion is something that is reserved for the commissioner of the SSA if he says someone's disabled. And it seems to almost backstab some people when they get that letter. Not just that the SSA isn't going to listen to it. Sometimes they get the impression that it annoys whoever's reading it on the SSA side, because now they think the doctor might just be in the pocket of the patient and just parroting the patient, and is biased. in favor of the patient instead of objective. So I don't think that's true, mind you, but I get the impression that some people up there might. Good job, DJ. That's what I would do. Thank you, Virginia. You should see me when I'm crabby. Let's see. Okay, Matthew, you're doing a lot of stuff here. I'm going to scroll past because we're trying to get to questions and the kind that can be answered here, Valerie, interesting question. Can ex-spouse contest or take it to court, etc. if filed for it? No. If he's paying you alimony, I suppose he could say to the family court, well, judge, that we have a change in circumstances. My ex-wife is now getting income from another source. Can we do the math again and see if I still have to pay the alimony? I suppose, and again, alimony rules vary by state. That's a state level law. That is something that popped in my head that could be possible. On the same token, Valerie, if you are paying alimony and now you can't work, I would go in, if that alimony decision was inflicted when you were still working full time, I would seek to see if I can get alimony changed due to change in circumstances. If the state accepts that kind of thing for a change in circumstances, change in financial circumstances. Hey, Breach, are you late to the game? What are you doing so late? Breach says, hello again from Lancaster, PA. I love Lancaster. Watching and taking notes helped me prepare for my phone hearing. Oh, good. Approved in November, SSDI, SSI. Got some back pay, SSI. Still waiting for SSD back check. Yeah. Sometimes that can be slow. But if you got your back pay SSI, then that is a step that is done by one set of people over here. And the other ones for the SSD can't do anything until that one's done. Now that this one's done, you're telling me, it seems to me that they should be hurrying up on this side. So maybe be a squeaky wheel if it's been more than few weeks. Sometimes you can call the field office and they'll say it's not here, which is true. It's at a payment center, most likely. But I know they can shoot up a message to them. So, that's worth asking for. Can you shoot them a message, please? Oh, Virginia, me too. My daughter gave this to me for Christmas. My prior one is a big, solid, probably stainless steel, but on a silver chain. I have a few of them. I feel like I'm turning into a collector. I love it. I even have earrings. We're talking about the cross stuff, guys. I don't know. I'm just really into it. I can't help myself. Addictive. So I'm always looking around for, dangles. No, he paid nothing. Said about it. Valerie, I'm sorry. He was not the most upstanding. Justin, good to see you again. Haven't seen you. Waiting for all hearing. ALJ hearing, I think you mean. Hopefully he or she considers a CE exam that I said I was disabled more than DDS did not do. Oh, he considers a CE exam. That said, I was disabled more than DDS did not do. Did DDS not give you a CE exam and then you were on your way to hearing? Yeah, I'm surprised that that's rare. I see CEs, consultative examination, guys, in every case in the last years, unless they are awarded without, which is still rare. A lot of times they make them go so they can really confirm that they're going to award. Oh, woodworker. I love woodworking. Good afternoon from Georgia. Any advice on going to temporary work period? Are you talking about trial work period? Sounds like you are. Well, the advice is if you can do it and keep your case safe, by all means, make the money. But that doesn't really give you a good answer, does it? I'd have to know your details, woodworker. I'm sorry. I do consults on that, just so you know. They are not free, however. But sometimes we go through a deep dive through the specifics and make sure the person knows the parameters in which you stay within. Now, Matthew, something tells me you didn't actually hear this, unless you were talking to the doctorate herself. You're a funny boy. Matthew says, I've heard it's good if you go with an advocate instead of an attorney if the advocate has a doctorate degree in organizational business management. Is this true? Highly doubtful. Organizational business management does not really lend itself to disability. I could almost see if you had an advocate who had been a VE, a vocational expert, Those people are kind of in tune with disabilities and accommodations and all that kind of stuff. But otherwise, don't get me wrong, the advocate you're speaking of, God bless her, she's probably studied up like any advocate and now knows SSD, and hopefully stays on top of it. But I don't think that degree, that would be like, I don't know, my economics degree. Oh, I was an economics degree at Rutgers many years ago in the Stone Age with a math minor. Yeah, math is my thing. Does that make me a better SSD attorney than somebody else? No, it doesn't. It has no bearing. The only thing I could say about advocates and I know some great advocates that are non-attorney reps. Super, super, super. Work their butts off. We are very like-minded. The only difference between that and an attorney is that the biggest difference from like a practical point of view, the attorney, if he commits malpractice, can be disbarred by his states and lose his law license. An advocate cannot lose their law license. There's less to lose. Now, the bigger we are, the harder we fall. Attorneys are bigger in credential with more to lose. So I think that's why the smart ones anyway are really, really more careful. In fact, I always get shocked at what I see when they're not. I'm like, you're an attorney. Like, what are you doing? It seems weird to me. It's like they think they're in this protected bubble because it's SSD and not New Jersey state divorce law where they'd be sued out the yin yang. But I don't see that there's a difference. I think a complaint can be had either way. If there's proof that there was malpractice, of course. Valerie, do you have to ask for your back pay or does it come automatically? I'm trying to click you on. Whoops. I'm flying through here. Am I making you guys dizzy? It comes automatically. Unless it goes on long, like a couple months, you don't have to really do anything. And then you want to start calling. Okay, I think, Justin, you're saying the DDS ignored your consultative examination. Is that right? How would you know that they ignored it? They didn't consider it at all. They don't actually tell you what they considered. I mean, they give you an explanatory page in your denial. It says all the things they had that they received, but that's usually what they ordered of the guys that you told them about. So they could say, we didn't get it from Jones and Dr. Smith, but we found we had enough to make a decision. I find that ridiculous when they say that, but anyway, the CE exam will be in the judge's file automatically, so you don't have to actually give it to them. Oh, My Hero Macadamia. What a cool name. Whoa, I made it to a live stream. God bless you for all you do. You have helped me with my case. Oh, I'm so glad to hear that. Thank you. Thank you for that share. Am I losing my voice? I forget to drink my water when I'm gabbing. Justin Jacobs says, cost of an appointment. Justin, are you talking about a consultation or having a review of your situation to see if it's a case we would take to represent in a battle for disability? Two different things. It doesn't cost anything to have your case. You fill out this little form. We look at it. You either get an email or a phone call telling you the scoop. We could take it or we could, after we talk to you a little bit. On the other hand, if it's not about representation to fight a disability claim, and it's something else, like you want to learn how to do your function report because you want to self-represent, or you're already receiving and you want to learn more about working safely while on disability, that would be a consultation, and that does cost. You can go to the website and look at that, okay? I don't really like to talk money in public. Let's see. Hal Jr., good question. How far back does the SSA go for medical records during a CDR? Usually a year, sometimes two. Sorry for the delay. I was looking at something else. Yeah, they don't go back very far. They really only want to make sure. Yeah, they don't want to see everything from the time they awarded you or from your last CDR. They usually just go. They look at what you're doing now. Valerie says she didn't read anything about back pay in her approval letter for SSD. Sometimes there's two letters, Val. One is you've won, and we're working on the numbers. And the other one is, here's your, I think it's called an award letter. I'm not sure. And it's from the SSA, not from the DDS or the OHO. And if there's going to be two, it'll be on the second one after they've done the numbers. And they say, and they break out what you're owed for this year, all the months in this year. They probably don't have it yet because, didn't you say, they figured out, was it SSI, Val? I don't know. I don't want to be mixing it up. Oh, Cindy, DAC doesn't have a spend down. DAC is not welfare. It's not SSI. There is no, Cindy, which is a great question, Cindy. I appreciate it. In case other people have this question, how fast do you have to spend down your back pay for DAC? You don't. You don't have to spend it down at all. That's Social Security. That's been earned, paid for by the worker. That is not welfare. That's not coming from the taxpayers. Not from your income taxes. That is not a handout, a gift, charity, or welfare. So he could say that. He can invest that. He can do all sorts of things. Don't waste it. If it's a reasonable amount, something can be done with it. If Mr. Vincent wants to know, is it better to get your own medical records or let SSA get it for you? I say, unless you want to pay a nice fee, let SSA get it for you. And that will depend on the state. Some states are very protective. Other states, I see bills for when they try. I smack them down with the HIPAA access rule and they shut up really fast, but they can try to charge a patient hundreds of dollars per request. So I need my hospital records from this, and then like a year later, they're still in the case and they need the next year. They try to walk into it. I would let SSA get them for you, but I would stay on top of it to make sure that they got them because a good adjudicator will call you or send you a letter saying we've been trying to get these providers and they're not providing them. Then you want to get on it. But I don't know that you want to necessarily do that in the meantime. First of all, it's going to be duplicates. And secondly, it might cost you. You should be focusing on your treatment. But if you're self-representing, Mr. Vincent, I do think you should be in good contact with the adjudicator to make sure, I don't mean every day or every week, but maybe once a month if they haven't reached out to you otherwise. Just say, hey, I just want to make sure, did you get all my, you'll have your list of who you told them to get. And any newbies you will have called them and told them about. I like it to be a phone call and a letter with proof that they received. But you want to make sure they got them. But you don't necessarily have to order them yourself. And therefore, you don't have to pay for it. Okay. Oh, Justin Jacobs. Okay, yeah. Just go to joydisability.com, and you'll see in the upper right-hand corner is a link for consultation, and that's gonna show you. You bet. No, Valerie, back pay is not assumed in an approval letter because many people don't get back pay. I forget what you said. They told you when you were found disabled, and you were getting early retirement, right? Am I recalling it correctly with all these other questions? Yeah. So no, that should be fine. It's not assumed in an approval letter because some people don't get back pay. So the approval letters are just saying you're approved. You know, you can take a breath, and then they have to go through all the numbers. Yeah. SSI is probably not the big thing you're going for, Valerie, if you have Social Security, disability, and Social Security retirement. That's just my guess. The Augustine machine. Okay. I think everybody here knows this answer, right? Thanks, Stephanie, for everything. Question. This is the Augustine machine. How accurate are the timeline estimates that SSA provides for application review? Very inaccurate, Augustine. Really poor. On any given day. I don't even pay attention to them. Just saying. Oh, Virginia, that's sweet. Official Nirvana. I see you again. Are you late? Look at overtime. I'm pushing 3 hours. I'm not supposed to do this. I'm supposed to be out after 2. My lawyer has finally put on my case, and I filled out a form with all my medical providers. Does this mean the DDS is now going to get medical records? They would anyway when you applied. Did you apply, Nirvana? Or is your lawyer accumulating data so that he will, draft up the application and submit it for you? Those medical providers go in kind of like the initial application. And then, because if you didn't send any medical providers, they're going to close your case. So even though the first technical piece of the application is done, they will still close your case if you don't get the medical stuff in, which if you're doing it on paper, it's the SSA 3368. If you are doing it online, after you click submit for the first part, it seamlessly goes into the medical portion. And that's where you start typing in all the spots, your medical treatment, basic dates, they ask for tests if you can remember them, medications, all that jazz. Okay? Mr. Vincent, you are so welcome. Ali Tovar was approved for SSI. Good for you, Ali. Okay, Cindy Gertman. If my daughter receives SSI and SSDI DAC, okay, and she got back pay, how do I find out how much back pay was for SSI versus DAC? It'll say in the letter. They break it out. So you should have, if you've gotten it and you've gotten the letter where it's broken out, you just have to kind of go through it. It can be a little complicated, but the SSI is going to be reduced if DAC was collected in the same month. Obviously, because that's unearned income to your daughter, so it kind of reduces what she needs for SSI. And if the DAC is you only get the SSI. She only gets the SSI because the DAC is small, under the SSI amount. So they top off the top with the SSI. But anyway, it should be coming in the paperwork if you haven't gotten it already. Ali Tovar. And my question is, how hard or easy is the non-medical review to pass? I have help with paying my credit card and phone is, it depends on your, I assume you're talking about SSI, Ali. Yes, SSI. See, I just said that above, right? If someone's giving you the money to pay for things, then that's going to be counted against you. So that might have happened when you weren't getting the SSI. Now that you get the SSI, that can stop. If they were gifting it to you, if they were loaning it to you and you have to pay them back, you're going to want to get documentation explaining that we had made this verbal agreement back in the day and blah, blah, blah. And this is how much they loaned me a month, $400 a month in total, blah, blah. And then both of you maybe sign it and confirm it. And if the SSA ignores it, you have to really stay on it. And that can affect your back benefits. So, you don't want them necessarily subtracting a $400 gift from your $900, SSI every month, leaving you with $500 in the back pay. So if it was a loan, you want to let them know. You want to get it documented by the lender. If it's just going forward, maybe it was a gift, but now they're like, well, once you get SSI, now you got to pay. You don't even need my loans anymore or my gifts or whatever. But the way it occurred and what you share to the SSA at your perk interview is what's going to decide what your back benefits are. How much offset, if any, is coming out of all those back benefits months. Yeah, it's income if someone gives you a gift. It's income. If it's a loan, it's not going to be counted as income, Ali, because you have to pay it back. And you just want to prove, you want to confirm with the other person in writing that it was a loan, with the expectation that as soon as you came into money somehow, whether it's disability or inheritance or whatever, when you came into money, you were going to start paying it back at $20 a month or whatever. If you get that document, if that was true and you get that documented, that can go to show that was not income gifted to you. It was in kind or cash income. it was a loan and you have a loan obligation. SSA is not going to go chase you down to make sure you pay them back. A lot of people default on their loans, but if it was actually a loan and you can both confirm that in writing and sign off on it, maybe use a 795 or use the bona fide loan form they have, which is like a L53 or something like that. I mix up the numbers, but I don't really need to use it that often, but when we do, we dig it up. Matthew, you're being ridiculous. Is it possible for SSDI lawyers or advocates to pay to scrub BSD Google reviews, or is that just a myth that I shouldn't worry about? Oh, all right, that's not really a ridiculous question. I think what you're asking is, should I trust those Google reviews? I really don't know. I don't go there. I don't look at them. I don't think I even know where I would find such a thing. I don't really care. So, I don't know. You know, you see all those ads, right? I don't know. I can't answer you. But I can, if you get word of mouth, it's best. And really, when you're under 50, Matthew, you know how I feel. It's like, it's hard enough to get a lawyer or an advocate. So, and they only have an incentive to win your case because that's how they get paid. So whether you trust it or not, I don't know, you know. But if you can get word of mouth, there's got to be message boards where people with SSD in Arkansas or wherever you're from, you know. There's got to be message boards, and you can ask, like, who did you use? You won? Who'd you use? What'd you think? Da-da-da. You know, that's probably what I would be doing if I was in your shoes. All right, I think we're done. I think we're done, guys. Right? It's breathing down 3 hours. My throat's doing pretty good, huh? A little scratchy, but other than that, all right. So be there or be square next Wednesday at 1 Eastern Standard Time. All right. Thanks, Rach. Thanks, everybody. I appreciate it. I had fun with you guys. All right, next time. Bye. Oops. Thank you for joining and taking a listen to this video. If you have any questions that relate to this or anything else with regard to Social Security, disability, retirement, SSI, etc., please do feel free to post it in the comments below, even if it's not necessarily related to this video. And I will see them. And if it's something I can do a video on, I will be happy to do that. If you are looking for representation in a current battle to prove that you are disabled, whether you have applied yet or not, and ideally, if you have not applied yet, that's when we like to come in and start from the beginning and do our wonders. You can go to joydisability.com, look up to your left, and there's a little link for a free SSD evaluation, and we will take a look at it and let you know one way or the other. If you are looking for a consultation, not representation, or you can't get representation for whatever reason, or it's a non-representational type of issue you need to review, you are more than welcome to order a prepaid consultation. It will be with me personally, and that link is on that same page, joydisability.com, but over on the upper right. Anyway, thanks for staying tuned, and I hope to see you every day, 9 a.m. with our little video shares or live Q&A if you want to join me live on Wednesdays at 1 p.m. Eastern Standard. Thank you so much. Have a great day. Bye-bye.